Not getting any of those folks in for some reason. Yep. All right. There he is. All right. This case number 22 CR 130, State of Ohio versus Stevie Don Colder. You're Stevie Don Colder appearing there from the jail?
Yes, sir.
All right. This hearing is being conducted remotely. Mr. Coulter is appearing from the jail by Zoom. Our attorney is Dennis Kirk, appearing remotely by Zoom. And representing the state is the Assistant Prosecuting Attorney, Dennis Kirk. The defendant was placed at the Twin Valley Behavioral Health Center, and after having been found to not be competent to stand trial, the court received a report on June the 2nd from the director, signed by the director of form in the cover sheet, and it was a report from the psychologist there at the facility, Tim Kuhn. Now, have each of the attorneys received a copy of the report?
State has it, Your Honor.
I have, Your Honor.
All right. Does either of the parties wish to add any additional testimony regarding this matter?
Nothing further from the state, Your Honor.
Nothing further from the defense, Your Honor.
All right. All right. Then it is the order of the court, based upon the report, that the defendant has been restored to competency, as defined by law, based on the report from Dr. Kuhn. This case will be restored to the active docket. The matter will be set for a pretrial let's see, I can't remember. Did we do any pretrials in this council, or did we just do
We did have pre-trials. I'm not sure how many, but I know we had at least one before the competency issue.
Right, okay. All right, well, we'll do the final pretrial then on June 22nd at 1 p.m. And the trial date will be July 10 at 8 a.m. And let's see, I'm looking at where current status of bond, because they do indicate she needs to continue to be medicated to maintain her stability, her competency. There had been some failure to appear, so the court's going to set bond at $5,000 plus the $171 service deposit and the same conditions. Now, Ms. Coulter, you have had a history of not appearing, not reporting to probation. If you do make the bond, you're still required to be under pretrial supervision. You report to the probation department upon release if you make bond, and comply with the conditions of pretrial supervision were previously ordered. All right. Anything further from counsel?
No, Your Honor.
No, Your Honor.
All right. You'll be remanded back to custody then, Ms. Coulter. Thank you.
Thank you.
All right. Okay, this is case number 23 CR 31, State of Ohio versus Alicia Looney. And you're Alicia Looney, appearing there on the screen marked Hyden County Probation Department. You'll have to unmute yourself, Miss Looney. Down there in the corner, left-hand corner, click on that little microphone with the red mark through it. That'll say unmute. You haven't got it yet.
Okay.
There
Yes.
we are. Okay. You're Alicia Looney, correct?
Yes.
All right. This is a sentencing hearing. Ms. Looney has previously entered a plea of guilty to theft, a fifth-degree felony. We have Mr. Wilson now.
Okay.
This is a sentencing hearing. She's represented by Sarah Barger of Hillsborough, Ohio, who's appearing remotely by Zoom, and also the state's represented by Adam King, Assistant Prosecuting Attorney. Now, Ms. I'm sorry, Mr. Kirk. I said Sarah Barger. I'm getting confused. Mr. Kirk. Yeah, Mr. Kirk. Thank you. All right. Now, Mr. Kirk, do you and your client both agree that this matter can be conducted by Zoom rather than her personal appearance before the court?
Yes, Your Honor.
All right. And you're all right with that, Ms. Looney?
Yes.
All right. Yeah, Mr. Kirk is out of town, so that's one of the reasons we needed to do this. Okay. If you should need to talk with him for any reason during this hearing, since you're not seated in the courtroom next to him, just let me know and I can put the two of you into a breakout room, and that means that the two of you will be on the screen. No one else will be able to see you or hear you. Okay?
Okay.
All right. Now, have each of the attorneys had an opportunity to review a summary of the pre-sentence report?
State has, Your Honor.
I was not able to before leaving, so I did not.
All right. Mr. King, on behalf of the state.
State would just ask that the court follow the joint recommendation, Your Honor. The restitution in this case is $4,213 to ABI Food Systems, and that would be joint and several with the co-defendant. Thank you.
All right, Mr. Kirk, on behalf of the defendant.
Thank you, Your Honor. Would ask court to follow the plea agreement. In this case, Ms. Looney was owned up to it, admitted to what happened, and advised me she fell on financial hard times and unfortunately made a bad decision to take someone else's funds to try to make ends meet. So she's owned up to that. Looks like in review of discovery and looking on the court's docket, she had one prior felony back in 2009 and successfully completed that community control in that case and hasn't had anything until now. So would ask the court to follow the plea agreement.
All right, Ms. Looney, anything you would like to say on your behalf?
No.
All right, it's the order of the court that you be and you are hereby sentenced to a term of 3 years of community control under the supervision of the Hyden County Probation Department under the following conditions. First, you obey all laws and all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed. You must be truthful in all statements you make to the probation department regarding your conditions. To keep them informed of your residence, place, and employment at all times. May not change either without prior permission. May not leave the state of Ohio at any time without prior written permission. May not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who is an inmate in those facilities without prior permission. You may not purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous ordnance, or weapons of any other type. You're not to purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of a controlled substance that has effects similar to those or drugs of abuse, nor may you have any instrument, device, or thing that may be used to administer or prepare them for administration unless you have a lawful prescription for both the device and the substance. And you must provide copies of those within 24 hours of receipt. You're to submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any alcoholic beverage or be present in places where they're sold or being consumed even if it's otherwise lawful. not to associate with anyone who's a co-defendant in this case, nor with any other person who has a criminal record, member of a gang or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense, unless that's approved in writing by your supervising officer. That would include any family members, except those you were living with immediately before the commission of this offense. And I believe you do live with Mr. Cannon, right?
Yes.
All right. I'm going to put in here not including co-defendant. Now, after the date of this order, you may not, well, that's not going to be applicable. All right, you must report any contact with law enforcement or arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any restitution, fees, or costs can be reviewed. If you're referred for an evaluation or assessment for any type of treatment, therapy, counseling, training, or other educational program, you're to report or to be submitted to that, and if there's a recommendation for programming, you're to enroll in and successfully complete that. You're paid the court costs to make payment arrangements to do that. You're required to pay restitution, and are you employed at this time?
I was not, but I just got hired yesterday, so I will start a new job tomorrow.
Where's that?
It's a Walmart distribution.
All right. You're going to be required to pay $150 a month, beginning. Today is June, so July, say beginning August the 1st, and then every month after that. Because I've only put you on for 3 years, that's 36 months. So you need to get the restitution paid in order to get off paper. So if you maintain that schedule, you'll be able to do that. Now you're also to comply with your Soda Paint Valley Mental Health Center program recommendations for treatment, if any. I see you have an assessment scheduled today. Oh no, you were seen yesterday, I'm sorry, seen yesterday. All right, so you're to comply with that. Now, by being placed on community control rather than being placed on in prison, sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property placed under your control where you're found at any time, any officer of the probation department, and you'll be required to sign a waiver to that effect. There'll be no fine imposed. You are ordered to pay restitution to ABI in the amount of $4,213, joint and several with your co-defendant. So I don't care how that's split, the $150, but it has to be paid.
Okay.
Now, you're also ordered to pay the court costs as a substantive order. If you fail to make payments on those, then the clerk can collect that through various means, including bank accounts, rate, wages, earnings, or other assets you may have. If that doesn't collect it, then the court can order you to do community service, give you credit for each hour you work in and out of the rate set by the court each hour you work, reduce your judgment by that amount until paid in full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice that with the court. You'll receive a copy. There will be a hearing. If the outcome of that hearing is that you have failed to comply, then at that time, the court can revoke your community control and sentence you to prison for between 6 and 12 months, fine you $2,500. If that happens, once you complete that prison term, it is possible that the Adult Parole Authority will put you under post-release control after your release for a period of up to 2 years. If they do, you'll be supervised on the terms they set. If they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to half of the prison term for one or more violations. However, if you commit a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time's left on that post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in a new case. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, you're to, then the probation will tell you what your next step is since you're now off of pretrial supervision and under the new conditions. All right, thank you. All right. All right, this is case number 23 CR 37, State of Ohio versus Richard Wesley Wilson. Mr. Wilson is appearing by Zoom from Counseling Center. His attorney is Sarah Barger, appearing from her office, appearing from the prosecutor's office, Mr. King, assistant prosecutor. Ms. Barger, do you and your client both stipulate that this sentencing hearing can be conducted by Zoom remotely rather than his personal appearance in the courtroom?
Yes, Your Honor.
Your agreement with that, Mr. Wilson?
Yes, sir.
All right. In the event that you need to talk with your attorney or ask her any questions during this hearing, you just tell me. I'll put the two of you into a breakout room, and then you can talk with her. No one else will be able to see you or hear you. Okay?
Yes, sir.
All right. Mr. Wilson has entered a plea of guilty to aggravated trafficking and methamphetamine, a 4th-degree felony. The matter was referred for a pre-sentence report. I have received that report and reviewed that. Have each of the attorneys had the opportunity to review a summary?
Yes, Your Honor.
All right. Anything from the state?
Only was contained in the plea agreement, Your Honor, and would ask that restitution to the task force be ordered in the amount of $220. Thank you.
Ms. Barger?
This is what is contained in the plea agreement, Your Honor. My client is aware of the $220 restitution.
All right. Mr. Wilson, anything you would like to say?
No, sir.
All right. And it is the judgment and order of the court that you be and you are hereby sentenced to a term of 3 years of community control under the following conditions. Under the supervision of probation department, you're to obey all laws of all jurisdictions, conduct yourself in all abiding manner at all times, report when and as directed, be truthful in all statements you make to the probation department regarding your conditions, just keep them informed of your residence, place, and employment at all times, may not change other without prior permission, not leave the state of Ohio at any time without prior written permission, you may not enter upon the grounds of any correctional facility or communicate with anyone as an inmate in any of those facilities or attempt to without prior written permission. Now, because of your conviction, you're prohibited under both federal and state law from possessing, owning, using, or having under your control or purchasing any firearm, ammunition, or dangerous ordnance. You're not permitted to do that as a condition of your community control, nor may you have any other weapons of any type in your possession during this period. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug abuse, CBD oil, kratom, or any variant or analog of any controlled substance has effects that are similar to those. Nor may you have any instrument, device, or thing that may be used to administer them or prepare them for administration unless you have a lawful prescription for both the device or equipment and the substance. And you must provide a copy of that within 24 hours of receipt. You're to submit to drug testing when and as requested. You may not purchase, possess, use, or have in your control any alcoholic beverage, nor may be present in places where it's sold, being consumed, even if it's otherwise lawful. You may not associate with anyone as a co-defendant in this case or any other person as a criminal record, a member of a gang or other criminal group, or any person who has in the past or could in the future, unless you commit a criminal offense or to violate these conditions, unless approved in writing by your supervising officer that applies to any family members that fall within that definition, unless you were living with them immediately before the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation, a common law marriage type relationship with another without prior permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay your restitution fees or costs can be reviewed. If you are referred by the probation department or the counseling center for that matter for any evaluation or assessment for further treatment, therapy, training, programming, etc., you'll submit to that. If there's a recommendation for that, you are to enroll in and successfully complete that. You'll pay the court costs to make payment arrangements to do that. You'll pay restitution of through the victim witness escrow account in monthly payments. I'm going to put that at $50 beginning. How long have you been down to the counseling center, Mr. Wilson?
I think I come November the 3rd, so about 7 months.
All right. I'm going to put in here beginning September 1st. Are you working at all yet?
Yeah, I've been working for 2 months now at Evans Soup Group. It's the pork rind factory here in Portsmouth.
All right. Well, no later September the 1st, you're to start making payments on that through the victim witness office and pay the service fees for that. And you're to comply with your substance use SUD treatment at the counseling center, TCC, and aftercare. Now, by being put under community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, vehicles, your residence, or any other property or place where you're found or that's under your control at any time by any officer of the probation department. There will be no fine imposed. There will be no license suspension imposed. You're ordered to make restitution in the amount of $220 to the Hiney County Task Force, which, as I indicated earlier, is payable through the victim restitution escrow account at the victim witness office. You'll pay service fees and charge for that. You're to pay the court cost, and if you fail to do so or make payments on those, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in any event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice of that with the court, and you'll get a copy. There will be a hearing. If the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your, if the court finds that you failed to comply, then at that time the court could revoke your community control and then sentence you to a term of imprisonment between 6 and 18 months and fine you $5,000. If that happens, once you complete the prison term imposed, the adult parole authority may, at their option, put you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised by a probation officer or by a parole officer in the term set by the APA, and if they decide that you have failed to comply, then they could return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. But if you're convicted of a new felony under post-release control, in this case, then in addition, whatever sentence could be imposed by the judge in the new case, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively, sentenced to the new case. Now that completes your case. You're no longer under the pretrial supervision conditions, but you'll need to contact Mr. Arjima to make arrangements for you to be transferred to the felony probation or community control officer. All right, anything further from counsel?
No, Your Honor.
All right, thank you. All right, I believe that completes all of the Zooms. Is that correct? We're not ready yet until we get a prosecutor. Okay, we're on record. Case number 23 CR 18, State of Ohio versus Tristan Nelson. The state is represented by Assistant Prosecuting Attorney Adam King. The defendant is represented by Attorney Danielle Wood, Hillsborough, Ohio. And you are Tristan Nelson?
Yes, sir.
All right, Mr. Nelson has entered a plea of guilty to theft and receiving stolen property. Count 1, the theft of fifth-degree felony. Count 3, receiving a first-degree misdemeanor. Now, Mr. King, were the victims of these offenses notified of the time and place and purpose of this hearing and their right to be heard?
Yes, Your Honor. All victims were notified and indicated that they would not be present for this hearing.
And you did confer with them regarding the proceedings?
Yes, sir, Your Honor.
All right. The court has received a pre-sentence report. I have reviewed that. Have each of the attorneys had an opportunity to review a summary?
State has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Thank you, Your Honor. State would ask that the court follow the joint recommendation and place the defendant on community control. There is restitution in this case. That would be $650 to Floyd Rhodes, and that would be a loan. And then there is restitution joint and several with the co-defendant to the Yankee estate in the amount of $380.37.
380?
$380.37 to the Yankee estate, joint and several with the co-defendant. That's all, Your Honor. Thank you.
All right. Ms. Witt, on behalf of the defendant.
Yes, Your Honor. We also ask the court to follow the joint recommendation. Tristan is in agreement with the amounts that Mr. King just stated for the restitution, and will be paying that. Since these charges, he has been actually doing well. He's working at Aristide full-time. He's been, from my understanding, compliant with probation. And these charges are his first felony. So we do ask the court to follow the recommendation for community control and treatment.
All right. Mr. Nelson, anything you would like to say?
I apologize, Your Honor.
How long you been working at Aristide?
About a week now.
Okay. You're working full-time?
Yeah, I'm working there full-time. I went back to that job. I worked there before.
Oh, okay. All right. All right. It is a judgment order of the court that you be and are hereby sentenced to a term of 3 years of community control under the supervision of the probation department under these conditions. You're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed. You must be truthful in all statements you make to the probation department regarding your conditions. You must keep them informed of your residence and place of employment at all times. May not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission, and you have to have that passed with you when you're out of state. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You're not to purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous, ordnance, weapon of any type. You're not permitted to purchase, possess, use, or have under your control any type of controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of a controlled substance that has effects similar to those. Nor may you have any instrument, device, or thing that might be used to administer or prepare those for administration unless you have a lawful prescription. And you must provide a copy of that within 24 hours of receipt. You must submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any alcoholic beverage, nor may you be present in places where those are sold or being consumed, even if it is otherwise lawful. You're not to associate with anyone who's a co-defendant in this case, nor with any other person who has a criminal record, is a member of a gang or other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions, unless approved in writing by your supervising officer. That applies to any family members, excluding those you were living with immediately before the commission of the offense. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any contact with law enforcement, any arrest, citation, or conviction, or any other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information and records so your ability to pay the restitution cost or fees can be reviewed. If you are referred for an evaluation or assessment for any type of treatment, programming, educational programming, therapy, etc., you are to submit to that. And if the evaluation or assessment recommends any type of programming, then you're to enroll in and successfully complete that. You're to make payment arrangements for payment of the court cost with the clerk. Now, were you evaluated for possible treatment by family recovery?
Yeah, I went up there and did my assessment.
And are you?
I forgot. I woke up late and I was on my way here. If I would have went down there and grabbed the paper, which I should have woke up early, but I slept in. I didn't mean to. I should have went down there and grabbed a paper that I was supposed to mint for you, but the probation, she faxed over to the probation department.
All right, now, are you supposed to do any treatment?
No, because every drug
Okay.
test that they did, I've been cleared.
All right. Now, by being placed on community control rather than being sentenced to prison, you're deemed to consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property place that's under your control where you're found at any time by the officer of the probation department. There'll be no fine imposed. Restitution is ordered to be made joint and see. Let me find my notes where I made that. Oh, here it is. Okay, to Floyd Rhodes of $650. And then the 380.37 is the joint and several, right?
Correct, Your Honor.
And 380.37 to the estate of Terry Yankee. Joint and several with the co-defendant. And it's a further order that you start making monthly payments on that. July 1st. And every month after that of $50. And you're to pay the service fees to the victim witness restitution escrow account for that service. Now, in the event that you fail to pay your court cost, in addition to being a violation of the terms of your community control, the court could also order you to do community service and give you, in this county, give you credit for each hour you work in an hourly rate set by the court, and each hour you work will reduce your judgment by that amount until paid full. Now, in the event that the probation department feels that you're not complying with these conditions, they will file a written notice that with the clerk, or the court, I should say. There will be a hearing. You'll be given a copy of that, of course. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time, the court could revoke your community control and then sentence you to prison for between 6 and 12 months as to count 1 and 180 days in jail in count 3. If that happens, once you complete your prison term, the Adult Parole Authority may, at their option, put you under post-release control for a period of up to 2 years, and if they do, you'll be supervised on the terms they set. If they determine that you have failed to comply, then they can return you to prison and make you serve an additional period, even though you serve the entire term set by the court of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, the judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively as sentence in the new case. All right, now is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, this completes your community pretrial supervision and the case. You report to probation department as soon as you leave here to let them know you've been put on community control so they can have you scheduled your intake to go over those conditions and set up your reporting. All right, so just go ahead, going down probation. Thank you. All right, Jaden, Florence, so Mr. Armitage. All right, case number 23 CR 17, State of Ohio versus Jaden Florence. Present on behalf of the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant's attorney, William Armentrout. Are you Jaden Nicholas Florence?
Yes, sir.
All right. Mr. Florence entered a plea of guilty to theft, a fifth degree felony, and receiving stolen property, a first degree misdemeanor. The matter was referred to the probation department for a pre-sentence report. I have received that. Have each of the attorneys received a summary?
State has your honor.
Defendant has your honor.
All right. Anything from the state regarding sentencing?
Thank you, Your Honor. The state would ask that the court follow the joint recommendation and place the defendant on community control. There is restitution in this case in the amount of $380.37 to the Yankee estate, and that would be joint and several with the co-defendant. Thank you.
Mr. Armentrout, on behalf of the defendant.
I would ask the court to place Jaden on community control. Court's obviously reviewed the precinct investigation. Has a very minimal misdemeanor record. He's been compliant with pretrial supervision. He's aware of the amount of restitution, agrees with that, and he understands that if the co-defendant does not pay his portion, that he has to pay it all. Stand up here. Sorry, sir.
And Mr. Nelson, anything that you would like to say?
No, sir.
Okay, you're working at Aristide at this time?
No.
Oh, wait a minute, I'm looking at Mr. Nelson's report. Are you working at all?
Yes.
Where are you working?
Leesburg, Matt Leisure Trucking.
What truck, who?
Matt Leisure Trucking. I work in the shop on stuff all day.
Okay, all right. All right, you can be seated, thank you. It's the order of the court that you be and are hereby sentenced to a term of 3 years of community control under the supervision of the probation department under these conditions. You obey all laws of all jurisdictions. Conduct yourself in a law-abiding manner at all times. You must report when and as directed. Be truthful in all statements you make to the probation department regarding your conditions. You must keep them informed of your residence, place, and employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. If you do, you must have that passed on you when you go out of state. You may not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You're not to purchase, possess, own, use, or have under your control any firearms, ammunition, dangerous ordnance, weapons of any other type. You may not purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of a controlled substance that has effect similar to that. Nor may you have any instrument, device, or thing that may be used to administer those or prepare them for administration, unless you have a lawful prescription for both the device or equipment as well as the substance. You're to submit to, and you must provide a copy of that within 24 hours of receipt to the probation department. You're to submit to drug testing when and as requested. You may not purchase, possess, use, or have under your control any alcoholic beverage, nor may be present in places where they're sold or being consumed, even if that is otherwise lawful. You're not to associate with the co-defendant in this case, nor with any other person who has a criminal records, a member of a gang or other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense to violate these conditions, unless that's approved in writing by your supervising officer. That applies to any family members that fall within that definition, unless you're living with them immediately prior to the commission of this offense. Excuse me. Now, after the date of this order, you may not marry or establish cohabitation and common law marriage type relationship with another person without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay the restitution fees or costs can be reviewed. If you're referred by the probation department for an evaluation or assessment for any kind of treatment, therapy, training, counseling, programming of any type, you're to submit to that. If there's a recommendation that there be programming, you're to enroll in it, successfully complete that. You're to pay the court cost of this action and make payment arrangements to do that with the clerk of courts. You're to pay the restitution in monthly payments. Your payment will be $25 a month beginning August the 1st. And you make that payment to the Franklin County Victim Witness Escrow account and pay the fee that is associated with that. Now, you're also sentenced to pay a restitution of $380.37 to the estate of Terry Yankee, joint and several with your co-defendant, Mr. Nelson. And again, you'll pay the fees associated with that, with those payments being made through the Victim Witness Escrow account. Now, by being placed on community control, Mr. Florence, rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, your vehicles, or any other property or place that's under your control or where you're found at any time by any officer of the probation department. The court will not impose any fine. The court cost is also ordered to be paid as a substantive order. It's a condition of your community control that you pay them, but if you, it's also a substantive order. And if you don't make payment arrangements and pay on those, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then the court could order you to do community service, and the county will give you a credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by the amount until paid in full. Now, in the event that it's alleged that you have failed to comply with this order, then the Adult Probation Department will file a written notice of that with the court. You'll be given a copy. There will be a hearing. You'll be entitled to have an attorney. The outcome of that hearing is that you fail to comply. Then at that time, the court can revoke your community control and sentence you to a period of between 6 and 12 months in prison and fine you $2,500 in count 1 and up to 180 days in jail in count 3. If that occurs once you complete the prison term imposed by the court, it may be that the Adult Parole Authority will exercise the option, put you under post-release control for a period of up to 2 years. If they do, you'll be supervised by a parole officer in the terms they set, and if during that period of time they determine that you have failed to comply, then they can return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. However, if you committed a felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively the sentence in the new case. Also, I forgot to mention that I do have from the probation department that you've been assessed by, or you're to be assessed by Soda Payne Valley on June the 15th. So you'll undergo that assessment, and if they recommend any programming or treatment, then you'll be required to comply with that. All right, now, so that completes your case. You'll no longer be under pretrial supervision, but you need to report to the probation department as soon as we're done to let them know you were put on community control this morning, and they'll transfer you to the your supervision to the felony community control officer. Anything further, counsel?
No, you're done.
All right. Thank you. Go ahead and go down there to probation. in jail today for those hearings this afternoon. For the pre-trials, a list of people that are in jail. They're doing Zoom.
Yes, written on that.
All right. All right, this is case number 23 CV 17, Highland County General Health District versus Joanne McKenzie. This is an action filed to abate solid waste. On a premises located at 11446 Dundee Drive, filed February the 6th. Let's see. Certified mail was returned unclaimed on March the 10th. And however, personal service was made on March 14th. Matter was set for a hearing on the motion for default. And notice was sent to the defendant. She has not appeared. Plaintiff's represented by Assistant Prosecutor King, Mr. Webb, on behalf of the Health Department. Is this a different property than the one we already had?
It's the same property, Your Honor, except now, instead of solid waste, we're dealing with sewage issues.
Oh, okay, okay. So it's, I did read the complaint of sewage. Okay, all right. All right, well, then the court will find that the defendant is in default for having failed to answer or otherwise defend against the case. So the court will order and grant the motion for default judgment, find that she has not abated the sewage nuisance that appears to be existing on the property, and therefore order that she be granted 60 days to abate the nuisance from the date of the filing of this entry, and to have an approved sewage system installed. She's ceased to generate household waste until that nuisance is fully abated, and is prohibited from residing on the premises until fully abated, and is ordered to pay the court cost. You might want to think about having somebody serve a copy of that on her, you know, from the department or something, taking a copy of it for her, so we mail it to her. She may say she didn't get it or something.
Yes, sir.
Yeah. Okay, thank you. The 11 o'clock's going to be a little bit late. She called and said the ride's going to pick her up in 5 minutes.
Okay.
Case number 22 CV 103, Highland County General Health District versus Renee Weaver. Plaintiff represented by Assistant Prosecutor Adam King, and you are Renee Weaver.
Yes.
All right. The court granted a judgment in favor of the plaintiff on October 26, 2022, in which it was ordered that the defendant abate the public health nuisance existing at the address 2448 State Route 138 Sardinia within 45 days. And she was permanently restrained and enjoined from accumulating storage solid waste on the premises, and was to have an approved sewage system installed, and to cease to generate household waste until it was fully abated, and prohibited from residing there until it was abated and an approved system was installed. Now, there was a motion to hold the defendant in contempt of that entry filed on April 24th. And the matter was set for hearing today, and Ms. Weaver has appeared. Now, you're not represented by counsel, Ms. Weaver?
No.
All right. Okay, Mr. King?
Your Honor, are you just asking for an update in general terms, or are you ready for testimony?
I'm sorry, what?
Are you just asking for an update? So, Mr.
Yes,
Webb,
so if you want to give me an opening statement first. And then.
Mr. Webb inspected the property yesterday. The solid waste issues and the sewage issues with the property have not been remedied.
Okay. All right. Do you have anything you'd like to say as far as a statement before we have any evidence, Ms. Weaver?
The only thing I'm lacking is the permit from EPA, because I don't have the $200.
Permit from the health department for your sewage system. That's what you have to install a sewage system.
No, I've got to get the permit from EPA.
That's not correct, is it?
Yes.
Could you address that?
Harvey?
So the permit through the EPA is a discharging permit
Oh, to discharge into a stream?
to the stream. And
Okay.
there is a $200 fee that has to be paid to the EPA.
Okay.
The septic system, she falls within the grant program, so the septic system will be completely paid. But there are certain things that can't be.
I got you. All right. All right. Well, Mr. King, if you want to go ahead and present testimony for Mr. Webb.
Yes, Your Honor. I'll call Philip Webb as one witness.
You just stand, raise your right hand, and be sworn. Do you solemnly swear the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may be seated. Just go ahead and testify from there, Mr. King.
Could you please state your name?
Philip Webb,
And are you currently employed?
with the Highland County Health Department,
And what are your job duties there?
to inspect septic systems.
And are you familiar with a property at 2448 State Route 138 in Sardinia?
Yes, sir.
Is that located in Highland County?
Yes, sir.
And do you know who owns that property?
Renee Weaver.
And do you see Renee Weaver in the courtroom today?
Yes.
Could you please point to her? Let the record reflect the witnesses identify the defendant.
So ordered.
And Mr. Webb, just in general terms, could you explain what concerns the health department has with the property at 2448 State Route 138?
The solid waste on the back of the property, the side of the property, the off-rim tires, and then the sewage. Those are the public health nuisances that we have.
And with the sewage issue, what specifically needs to be done to remedy and address the situation?
We have given a site evaluation form that discusses having the property surveyed, having a acquired easement to discharge, acquire a permit through the EPA, submitting water records to our office, and submitting a design for that.
And have you discussed these issues with Ms. Weaver? Is
Yes.
she aware of what needs to be done to remedy the problems?
Yes, sir.
And did you personally inspect the property yesterday?
Yes.
Did you take photos while you were there?
Yes.
I'm going to hand you what's been labeled Exhibit 1 for identification purposes. Do you recognize this photo?
Yes, this is the back of the property. This is on the adjacent property, but the pipe is coming, it's freshly dug, where the septic system was failing in the past, where it was coming up and surfacing. They have now tied into and put a pipe that goes to the neighbors, and there is sewage in that creek there.
Okay. I'm going to hand you what's been labeled Exhibit 2. Do you recognize that?
This is the back of Miss Weaver's property, and there's a large amount of solid waste.
Going to hand you what's been labeled Exhibit 3. Do you recognize that?
This is still the back of the property there with solid waste, buckets.
I'm going to hand you what's been labeled Exhibit 4. Do you recognize that?
This is the side of the property where a large amount of solid waste is.
And finally, Exhibit 5. Do you recognize that?
This is the black discharge or the sewage that was in the creek.
And our plaintiff's exhibits 1 through 5, true and accurate depictions of the property at 2448 State Route 138 as it appeared on June 6th of 2023?
Yes, sir.
I have no further questions.
Ms. Weaver, do you have any questions you'd like to ask Mr. Webb?
Here's the photos if you want to look at them.
I don't have no questions, but this right here, this pipe that he's talking about, is not tapped into my line.
Okay, well, you have to, you can testify on your own behalf, but right now, the only question is, do you have any questions you'd like to ask Mr. Webb? If you do, you can ask him questions. If you want to testify about what you believe the facts are, you can do that when it gets to your case. So do you have any questions? All right. Mr. King, anything further?
I do have just one additional question to Mr. Webb, if I can see this. Can I see if he can have his back? Mr. Webb, looking at plaintiff's exhibit 1 in this, I see a pipe in this photo that looks like it's coming out into a stream. Could you explain what we're looking at in this photo?
So the septic system is coming out from the back of the house there, and then it goes to a tank, and then there's a leach field that is directly under this trailer. And this is freshly dug dirt where they have put a pipe in to eliminate the sewage coming up in their backyard, which we have evidence of sewage in their backyard. So to remedy that, they dug this up and installed a pipe so that the sewage is not in their backyard, but it is now in the creek.
And the sewage that's coming out of this pipe is coming from the property at 2448 State Route 138?
Yes, sir.
I have no further questions.
All right. Any other witnesses?
No other witnesses, Your Honor.
You'll move admission, you exhibits?
Yes, I would ask that exhibits be admitted.
All right, they'll be admitted.
Would you like me to
Yes,
approach?
please. Yeah, please, if you would bring them up. All right, now, Ms. Weaver, this is your opportunity to testify on your own behalf or present any evidence that you would like to present. So, do you wish to testify?
Yeah.
All right, if you would stand and raise your right hand to be sworn. You solemnly swear the testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, you may be seated and testify from there. Just go ahead and tell me what you feel the facts are that, because you're here on a question of whether or not you are in contempt of court, of the court's order.
Well, the black pipe that he's talking about, it was a clay pipe, or
Is what?
it was a clay pipe to start with, and it's not tapped into my property.
Okay, anything else?
I have 2 drains coming out, and one of them is a basement drain. And that's the only thing that I've replaced. And the septic tank is not leaking. What it was where the septic, or the water was coming out of the basement drains and it's broke. And you got water sitting, it's gonna turn black. But it's not sewage.
What is it?
It's from the basement. I showed him the pipes that broke under there and everything. I left it open so he could see it.
All right, anything else? Let me ask you this, these photographs that show all the stuff that's on the property, you agree that stuff was there when these pictures were taken?
Yes,
All right,
I was told I was allowed to have them.
I'm sorry?
I was told by Courtney that I could have them, as long as they had holes in the bottom, so no water stayed in them.
Okay, I'm just talking about all the stuff that's like in Exhibit 4 is behind the house, all that trash that's out there, it just looks like just junk. And by what it looks like to be by the back of the house, a horse trailer or some sort of trailer, and on the side of the property, in Exhibit 2, and also Exhibit 1, or Exhibit 3, I should say. Why haven't you removed all that stuff? You've had since October to do it.
The buckets and the barrels, Courtney said it was okay to keep. That's what I keep my stuff in. My aluminum cans and copper and brass.
Well, you can keep garbage cans, yeah.
What is it?
So you can have garbage cans, keep stuff in. I'm talking about all the stuff that's out there. I mean, you've seen the pictures, there's a bunch of junk out there.
No, he got them before you have to look at them all. I only seen the first one.
Anything else you'd like to say?
I'm trying to get the money up to get the EPA.
Okay, well, how long ago have you, this is
I'm not allowed
June.
to work.
This is June, and October 20 of last year was when you were ordered to comply. So that's been 8 months. When are you going to have the money to pay it? Are you working?
I'm not allowed.
You're not what?
I'm not allowed.
Why?
I was in a head-on collision.
I'm sorry?
I was in a head-on collision
When was that?
in 2003.
Are you on disability?
No. They said I owned too many assets.
You're not allowed to work, but you're not on disability.
Yes. I've
Okay.
applied and applied and applied.
All right. Mr. King, do you have any questions you'd like to ask the defendant?
No, Your Honor.
All right. Do you have any further evidence you'd like to present, Mr. King?
No, Your Honor.
Do you have any other witnesses?
Matt lives at the house with me.
Okay, you want him to testify?
Yes.
All right. Sir, would you stand up and raise your right hand? You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you need to have come up here so I can hear you.
He can't talk that loud. He's got Parkinson's real bad.
He can't what?
He can't talk that loud. He's got Parkinson's real bad.
Well, if he can't talk loud enough for me to hear him, it's not going to be much help.
I can talk, it's not that loud.
I'm sorry?
I can talk, it's not that loud. I can talk, it's not that loud. That's my throat.
What's your name, sir?
Douglas Neal.
All right.
Douglas Neal.
I
Douglas
can't
Neal.
hear you.
Douglas Neal.
Put that mic in front of me. Okay. What's your name, sir?
Douglas Neal.
All right. You want to ask him any questions, ma'am?
Can he explain what?
Yeah,
Ask him questions. You have to ask him questions, and he can answer questions.
When Courtney Hall was there at the house?
Yeah.
Do you remember what she said about that stuff?
Yeah, she said we could have it as long as it changed daily, because we scrap for a living. I don't get a disability either, and she scraps every day. And Courtney said that we could have, we had a refrigerator out there and drove it a while back, and she said something about it, and we told her it was gone. And told her stuff changed daily, sometimes two, three times a week. But you can't just get aluminum cans, whatever. You have to get metal and stuff like that's in the pictures. All that stuff had been in the truck, but we emptied the truck because we had an opportunity to get more scrap yesterday, so we had to go get the scrap, and so we unloaded the truck, and then, you know, I don't know what to say. I mean, it doesn't sit like that. It's just, you know, you gotta do what you gotta do, you know, when you have limited resources.
Yeah, I'm having trouble hearing you. I can't understand anything you're saying.
I said, you have to
Do you have any other questions you'd like to ask him?
Do you remember what Courtney said the other day when she was at the house?
Pertain to what?
The drain?
Yeah, she said, the drain was messed up, but she said, you know, she see below the pipe, the septic was okay, and said she didn't see any septic problems, but she said that water at the end was what's called brown water or something like that. It's like pond, like stagnant pond water from where the, you know, basement floods and the sump pumps it out. And I don't know, maybe the drain tile wasn't deep enough or whatever, but it's down at the end there and it comes out and it looks like, I don't know, it looks like sewage, it's just brown water. And there's no toilet paper or anything like that. It's not. It's just brown water from where it sits, you know. I mean, he did his assessment yesterday based on what he saw on top, but he didn't probe. We didn't find it.
I'm sorry, but I can't hear him.
I said he did his assessment yesterday based on what he saw on top, but he didn't take a probe and check to see if we had tied in anything. We didn't tie in anything. We replaced the drainage tile and fixed that problem. And sewage was fine throughout. I mean, I don't know what else to say. But. And the reason she hasn't paid this stuff is because, you know, you don't make big money when you scrap and you got other bills. And I've been fighting Social Security for like 3 years now, and they did finally just approve mine. So we should go to permits and stuff we need to do within the next 3 months, I guess. However long I don't know how long it takes me to get my first check, but I'll get back paid and stuff too. So I don't know. But it's not like we sit on our hands. I mean, I do what I can do, you know. It takes me a little while longer, but I get it done. I can tell you it was done correctly for the system she has, you know.
All right, anything else you'd like to ask him?
When that yard was dug up and tilled up, was there any pipe attached to another pipe?
No, I didn't attach anything to it. There's corrugated like clay pipe, and we didn't do anything to that. But I laid down the corrugated, what you call French drain pipe, you know, the plastic pipe with holes in it. And
all right, the question before the court is whether you're in contempt or not. So we need to focus on that because it's alleged that you have not obtained a permit to install, you have not installed the new system, and you've not removed the solid waste. Those are the issues before the court. So any other questions you'd like to ask him about those matters?
Was the solid waste removed?
Yes. I mean, he spoke of the tires in back. The other tires back there, they're good tires that I sell, and none of them have water or anything like that, and there's no water issues, nothing like mosquitoes or whatever else issue is with it. There's nothing like that. I mean, the driveway was a mess yesterday. I said I unloaded everything. And you can't just take a load in everything all together anyway. I have to sort through it and get the best money. I have to separate aluminum from copper and stuff like that. And
anything else?
When can we come up with the $200 for EPA?
I can't hear you.
When can we come up with the $200 for EPA?
My lawyer said
well, he's not the owner. You're the owner, right?
Yeah.
Okay. Now the question is when he can't, isn't when can he come up with it, it's when can you come up with it?
Well, what?
By the end of August.
Oh, no, ask him questions.
Oh.
I'll say for it.
There's no question in front of you.
All right.
I'm done.
All right, do you have any questions?
No, Your Honor.
All right, you may step down, sir. You have any other witnesses, Ms. Weaver?
No.
All right, Mr. King, closing.
Thank you, Your Honor. The defendant was ordered to have this property cleaned up and the sewage issues remedied. That order was back in October of 22. She was ordered to have that done by December 12th of 22. Here we are in June of 23. The photos that Mr. Webb took yesterday speak for themselves. The property is full of solid waste. There is still not an approved sewage system on the property. There's a pipe that's feeding sewage into a stream. Mr. Webb has attempted to work with Ms. Weaver to explain what needs to be done, the steps that she needs to take. She's done nothing. I think it's clear at this point, Your Honor, that she is in contempt. Thank you.
All right, Ms. Weaver, any statement you'd like to make?
It has been cleaned up, and there is no sewage out there in my yard. And I'm not tapped into nobody's property or anything. I don't know where the drain comes from that he's talking about with the black pipe. That I don't know. That's not on my property. It's an alleyway between me and my neighbor. And it used to be this Buford Elementary School. The sewage, it came over there. And they tore the school down and they closed off the sewage. But that property's not mine.
Well, Ms. Weaver, we're not relitigating whether there was sewage there or not because the court made that, you entered a judgment against you because you didn't defend against the allegation. And you were ordered to do specific things. And you've not done that. You're required to get install an approved septic or sewage treatment facility, and you're required to do whatever it takes to get that done, which would include getting the permits that are required under the law. Now, it's clear that there is sewage there. There's sewage coming through that pipe, and it's clear that it's coming from your property. And it was clear back when the court granted it that you had a failing system. And so it has to be fixed. Now, I also ordered you to cease residing there. You should continue to reside there. Now, here's the situation. If you can't afford to get the $200 to get it fixed, then you're going to have to leave the property because you cannot continue to live there and generate sewage and discharge it into a stream, untreated sewage. And that's a violation of the EPA rules as well as the health department rules. And as far as the situation on the solid waste, if you've cleaned anything up, I don't know what it was, but there is all kinds of stuff lying in there. I mean, I'm looking right here at Exhibit 2 and Exhibit 1. Exhibit 1 actually shows the discharge pipe in a ditch that clearly was dug from your property over there. And that shows all kinds of just junk and trash in the yard. Exhibit 4 shows all the stuff that's there behind your house, and then Exhibit 5 shows the close-up picture of where that discharge is, and that clearly is sewage. So you're in contempt. So the order of the court is that you're sentenced to 30 days in jail, and I'm going to give you the chance to do what's called purge your contempt, and that is avoid going to jail. Now, I'm going to be able to do that under these conditions. First, that you apply for permit from EPA. Second, that you apply. Has there been any application for an approved system at all?
So
you have the design and everything. Is it all ready to go? She just has to sign it?
the design has to be, with the discharging aeration system, it's kind of its own package plan. She'll have to go to a designer, but with the grant, it's paid for.
All right, so she'll have to apply for a design for a system,
But the things that we need are that survey to know where that property line is, and then the easement on the neighbor.
A land survey?
Yeah.
And is that included in the grant?
That is not, and the easement recording is not either.
Okay.
Those have to be out of pocket.
It needs to have an easement, all right. So, it's ordered that Mr. King wants you to prepare this entry, that include in there that she's to do all the things that is required for the approval of a system design and easements and so forth. I'm going to give you 60 days to get that done. So today is June the 7th. I'll give you until August the 11th. We are having a hearing. Now let's see. I think that's, can't remember. We're back first and third Fridays in drug court. Yeah, so August the 11th at 2 p.m. there will be your report here for a hearing on what's called a purge hearing. And at that time, if you haven't done these things, or in the event that you haven't done all those things, then you have to move out of the premises and cease generating any kind of waste on a property, sewage. And you also will have all of the solid waste removed by that time. So I'm going to give you about 65 days. And if you don't have that done, then you're going to go to jail. Now, understand it's hard, but this is a public health hazard. And we can't allow people continue to live on property and say, well, I don't have the money to fix it up, so therefore I don't have to obey the law. That's not the case. The law says, you know, that you have to do it, and because we can't allow you to endanger the health of your neighbors and other people from the pollution of that stream and the production of that stuff on your property. It's just can't be done. So if you're not able to get this money done to do all these things, and again, if you're making progress, you know, and the health department, the police, or the prosecutor's office notifies me, I'll certainly be willing to extend that out some to give you some more time. But not come in here the day before and say, or that day and say, well, as of yesterday, I started the process. No, you need to start right now. I mean, you need to start yesterday, and you haven't. So, you know, because if you can't afford it, then you're going to have to walk away from the property and go live somewhere else, and not live on the property, not run any water through it, not flush the toilets, not do any washing, generate no waste from that property, because that's polluting the stream or the water supply, that ditch certainly, and getting into the property, getting into the water table. So you can't do that. It's just not permitted. And you know, if you can't, maybe you should try selling a house or something like that. I don't know what your situation is, and I appreciate the fact that, you know, this is going to cost a lot of money and you may not be able to afford it. And if that's the case, then the answer is move on, leave the property. That's the only other way I can see that you have an option. So that's your other option you're given if you can't do any of those things. But you only have until August the 11th at 2 p.m. your report then. And if these things aren't done by then you will be going to jail for 30 days. When you get out, if you don't do it, they'll file another action against you. And we can continue to do these 30 days in jail for the rest of your life. So, you know, you don't want that. All right. So, Mr. King, please prepare the entry.
Yes, sir.
All right, thank you.
Please rise.
his attorney. All right.
She's not, I don't think she's in here.
And then Humphrey's attorney is Barger. Okay, she's not on. Appearing there from the probation department.
Yes, sir.
All right, this is case number 23 CR 78, State of Ohio versus Joey Ray Dixon Jr. This is a pretrial being conducted by Zoom. Mr. Dixon's appearing from the probation department. His attorney is Jacob Wagner, appearing from his office. Appearing from the prosecutor's office, prosecuting attorney Collins. Defendant is charged with 6 counts of endangering children. This is a first pretrial. Final pretrial is July 5. Trial date is July 27. Now, I see there was a request for discovery and a compliance by the state. And have you filed yours yet, Mr. Wagner?
I'm not, sir. I'm still weeding through the state's discovery.
All right. Well, it'll be due by the final pretrial. Do you anticipate any pretrial motions?
Not at this time, sir.
Okay. Has there been a written plea offer provided?
Yes,
Yes,
Your
but
Honor.
I apologize, Ms. Collins.
I just said yes.
Your client aware of it?
He's not, Your Honor.
All right. All right. Well, you need to get in touch with your attorney then, Mr. Dixon, to discuss that matter. Any other matters need to discuss at this time?
Yes, sir, Your Honor. Well, I apologize again. Your Honor, if I may, actually, in looking at the trial date, I was going to request this anyhow. I'm actually out of state on the 27th of July. And again, my client's out. We would be willing to waive time. I've actually spoken to Joey about this. We would waive time, Your Honor, if the court would grant us a continuance at this time.
All right. Is there any objection by the state?
They are indicted together and right now can be tried together, so.
Well, yeah, we're going to, there are victims involved, or alleged victims, so we'll have to have a hearing on that. So you'll have to file a motion, and we'll have to have a hearing involving both defendants. And then the court will make a decision at that time. Is the co-defendant in custody as well?
She's not in custody.
Not in custody, I mean, out of jail as well? Okay.
She is.
All right, well, get your motion filed, and then we'll set the hearing, and we have to give 10 days notice to the prosecutor, and they have to give 7 days notice to the alleged victims, so, because they have a right to be heard on the matter. So we'll deal with it in that way then. All right,
Yes, sir,
anything
Your Honor.
else that needs to come up?
No, sir.
All right, then get in touch with your attorney, Mr. Dixon, and we'll most likely be having another hearing on that motion for a continuance. All right, thank you.
Yes, sir. Thank you, Your Honor.
All right. All right, Commissioner. Was Miss Leith, actually, she's not scheduled to 2. Yeah, okay. So she was supposed to come back, I think, to your office for this afternoon. So.
Or go to TCC.
Pardon me?
Either be here at the office or go to TCC.
Okay, yeah, if you think she's at TCC by now? All right, this is case number 22 CR 237, State of Ohio versus Zachary Thomas McGraw. You're Zachary Thomas McGraw, appearing there from the jail?
Yes.
All right, Mr. McGraw's attorney is Catherine Hapner, appearing, this hearing is being conducted by Zoom, and she's appearing from her office, and appearing from the prosecutor's office, Prosecutor Collins. The defendant is charged in a single count indictment with aggravated possession of methamphetamine, a 5th degree felony. And this is a first pretrial, final pretrial set for July 5, and trial date set for July 22. And I see that the state did provide a bill of particulars and discovery, and I do also then see that there's been a motion for intervention in lieu of conviction. And did the state receive that?
They have received the motion, Your Honor.
Okay, all right. Well, the court then will order that where do you live, Mr. McGraw?
Greensboro.
Greensboro, okay. All right, the court will order that an evaluation be made, and has there been stipulated questions signed?
Now, Your Honor, I'm a little frustrated because I went out to the jail to have him sign those, and I was informed he was no longer there. Well, obviously he is, so I'll go back out this afternoon and get those signed.
Yeah, he was in Ross County, but he was brought back this morning, I think. So.
Okay, well, that might explain that.
Yeah, yeah. You just got back here this morning, didn't you, Mr. McGraw?
Yes, sir.
Yeah, okay. All right. If you have those, if you could fax them out to the jail, and then the deputy could get him to sign those and fax it back to you.
Okay.
You have the questions?
I do have the questions.
Okay.
I just typically go over the questions with the client to make sure that everything is accurate, that there's no issues, but I can fax them out there.
Okay. All right. Those questions, Mr. McGraw, are to determine if you're eligible. There'll be a couple you can't answer. One is you're not in a certified treatment program, and forgot what the other one is. But in any event, just read those over, and those are just the preliminary questions so that you can be considered for this program, which would allow you to avoid a criminal conviction if you complete a course of treatment, if you're in a proper course of treatment program, and this is what you want to do. Okay?
Okay.
All right. Thank you.
Great. Thank you.
All right. Now we have Kelly. Okay. Are you Kelly Marie Humphrey, appearing from the jail?
Yes.
All right. We have 3 cases involving the same defendant, Kelly Marie Humphrey. Ms. Humphrey is appearing by Zoom from the jail. Her attorney is Sarah Barger, appearing from her office. Appearing from the prosecutor's office is Prosecuting Attorney Collins. In case number 22 CR 133, the defendant is charged with 1 count of theft. In case number 23 CR 26, she's charged with 1 count of tampering with evidence. That's a 3rd degree felony. The theft is a 5th degree felony. Case number 23 CR 168 or 068, she is charged with failure to appear, 4th degree felony. Now, Ms. Barger, do you and your client both agree to conduct this proceeding by remote Zoom rather than by a personal appearance in the courtroom?
Yes, Your Honor.
Now, you're all right with that, Ms. Humphrey?
Yes.
All right. With regard to case number 22 CR 133, do we have a victim or victim representative present, Ms. Collins?
Not present, but what she was notified of the hearing today. Well, I don't think she's present. But she was notified of the hearing and her right to be present, and that notification was made on May the 9th.
All right. And has she been in contact with you at all then?
Yes, we've been in contact with her.
All right, so you have conferred with her and she was aware of the nature and purpose of this hearing and her right to be
Yes.
heard? Okay.
Yes.
All right. Now, Ms. Humphrey, I've been presented with plea of guilty forms in each of these three cases, which indicate that you're going to withdraw your not guilty plea and plead guilty to the charge in each case. So I'm going to hold up, the first one is 22 CR 133, the plea form for the theft case, and ask you if you recognize that first page.
Yes.
And on page 3, there is a sentence about a fourth of the way down that reads, I enter this plea voluntarily. Below that's his signature, indicates it was signed on 6/5/23. I'm going to hold that up to the camera, and is that your signature?
Yes.
All right. In case number 23 CR 26, I'll hold that first page up, and you recognize this is on the tampering with evidence case charge. You recognize that?
Mm-hmm. Yes.
And on page 3, there's the same sentence and another signature and another date of 6/5/23. I'll hold that up, and is that your signature?
Yes.
All right. And then on the 23 CR 68, the failure to appear, I'll hold that up to the camera and ask if that is, you recognize that page?
Yes.
And on page 3, there's also the sentence, I enter this plea voluntarily, and the date of 6/5/23, and is that your signature there?
Yes.
When did you sign these three agreements? You signed them out on the 5th, which would have been, I believe, Monday?
Yes.
And before you signed them, did your attorney go over them with you and explain everything to you and answer any questions?
Yes.
And did you understand that when you signed these agreements that they were agreements to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes.
And do you feel that you had enough time to fully consider this matter before making this decision?
Yes.
And do you feel that you were coerced or forced in any way into doing this?
No.
So you've entered into this agreement voluntarily
Yes.
in each case?
Each case, yes.
And it was 2 days ago, and so today's Wednesday. Is this still what you want to do in each case?
Yes.
All right, now, case number 22 CR 133 says you're going to plead guilty to theft under 2913.02A1, a felony of the 5th degree. And it further states you understand the maximum prison term for that is could be 12 months, the minimum could be 6 months if prison is imposed, and there's a fine of $2,500. On case number 23 CR 26, it says you're going to plead guilty to the tampering with evidence charge under 2921.12A1 of the Ohio Revised Code, a 3rd-degree felony. You understand that the prison term on that is possible between 9 and 36 months, and in the increments provided by law, a fine of $10,000. You understand that?
Yes.
And in case number 23 CR 68, failure to appear under 2937.99, 4th-degree felony, and it states you understand the possible prison term for that's between 6 and 18 months and a fine of $5,000. And you understand that?
Yes.
Now, if you were to be sentenced to prison on all three of these charges, Ms. Humphrey, those sentences could be ordered to be served consecutively. And so the maximum sentence for the theft case is 12 months. Maximum sentence for the tampering with evidence is 36 months, so that's 48 months. And the failure to appear is 18 months, so that's a total possible 66 months in prison, and a total fine available in all three cases of $17,500. Do you understand that?
Yes.
Now, in the event that you are, well, first of all, are you facing any felony charges in any other jurisdiction besides this one?
No.
Are you currently on probation, community control, parole, or post-release control for a felony?
No.
Under the law, if you're convicted of these offenses and sentenced to prison, it is possible the adult parole authority at the conclusion of your sentence would put you on what's called post-release control for a period of up to 2 years. They don't have to, but they can. But if they do, you'll be supervised on the terms they set by a parole officer. And if during that period of time they determine that you have not complied, they could return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a limit or cap of half of the total prison term for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in that new case could impose, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in that new case. You understand that?
Yes.
Right now, under the law, I'm not required to sentence you to prison for any of these offenses. I can impose what's called a non-prison or community control sentence. And what that means, instead of going to prison, you'd be put under supervision of the probation department for a period of up to 5 years under the term set by the court. And if during the period of time you were being supervised, the probation department thought that you were not compliant, they would file a written notice of that with the court. There would be a hearing, and you would be entitled to have an attorney. And if the outcome of that case was that you had failed to comply, then at that time, the court could revoke your community control and then sentence you to a total of 66 months in prison and fine you $17,500 total. You understand that?
Yes.
All right. Now, the charge in the theft case alleges that on or about the period of September 10, 2021, continuing through December 24, 2021, in Highland County, Ohio, you did with purpose to deprive the owner, Laura Goolsby, DBA Ohio Helping Hands LLC, of their property, knowingly obtained or exert control over said property, to wit, U.S. currency, $4,634.69, and other miscellaneous items without the consent of the owner or person authorized to give consent, value of the property being greater than $1,000 but less than $7,500. So that's the fifth degree felony theft charge. Now, the 23 CR 26 case alleges that on or about January 19, 2023 in Highland County, Ohio, that you did, knowing an official proceeding or investigation was in progress, was about to be or likely to be instituted, did alter, destroy, conceal, or remove a record or document or thing with the purpose to impair its value or availability as evidence in such proceeding or investigation in violation of section 2921.12A1. So that's the tampering with evidence charge, the third degree felony. And then the third case, the failure to appear, alleges that on or about March 8, 2023 in this county, you did recklessly fail to appear as required in Highland County Common Pleas case number 22 CR 133 after having been released pursuant to ORC 2937.29, and the release was in connection with the charge of the commission of a felony. So that's the failure to appear, the fourth degree felony. Now, Ms. Humphrey, do you understand what it is you've been charged with in each of those three cases, what the state is alleging you did, and when, where, and how they allege that you did it?
Yes.
And have you discussed the nature of each case, the evidence in each case, the possible defenses you might try to raise in each case, and the possible outcomes of a trial in each case with your attorney?
Yes.
And are you satisfied with her advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you in any way to get you to plead guilty in this matter?
No.
All right. Now, in each of these agreements, on page 2, there are some lines that are printed in bold and underlined, which have the significant terms of the plea agreement. So I'll read those as follows. And this is 22 CR 133. It says, defendant shall enter plea of guilty to the indictment. State defense jointly recommend community control and STAR. Defendant agrees to make restitution to Ohio Helping Hands LLC, the amount of $4,412.24. In case number 23 CR 26, it reads, the defendant shall enter plea of guilty to the indictment. State and defense jointly recommend community control and STAR. And then case number 23 CR 868, the third charge. Defendant shall enter a plea of guilty to the indictment. State defense jointly recommend community control and STAR. So the recommendation is that you get community control or probation and go to the STAR program. Now, you understand that the recommendation of community control is not binding on the court. So if you decide that if you do plead guilty, once I've heard all the information that's submitted, if I decide that's not the correct sentence, then I could sentence you to as much as 66 months and fine you as much as $17,500. You understand that,
Yes.
right? Now, you have do you hold any license or certification from any state governmental agency that regulates any occupation or profession in this state?
No.
All right.
I was working on trying to get my license for nursing, but because I was doing STNAs and stuff like that, but I don't have one.
Are you a licensed STNA right now?
No.
Okay. All right. All right. Now, you have certain constitutional rights you must understand before I can accept a plea from you. First, you have a right to have an attorney. Ms. Humphrey Ms. Barger was appointed to represent you in these cases. Now, that appointment wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you would like her to provide. So, if you decide that you don't want to do this, that you don't want to plead guilty in any of these cases, or any one or more of them, then you would still have an attorney to represent you and defend you, including a trial on each of the cases if that's what you wanted. Do you understand that?
Yes.
Now, under the Constitution, Ms. Humphrey, you have a right to have a jury trial in each case. And what that means is that a group of 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on the trial date in each case. Once those jurors were selected in each case, the evidence would be presented. They'd be instructed on the law by the judge. And in each case, that jury would have to decide by a unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive or give up in writing your right to have a jury trial. And in that case, you would have what's called a quarter bench trial in any of the cases if you selected that option, any one or more, or all. And what that means is that instead of a jury hearing the evidence in that case, that would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes.
Now, in each of these cases, you have a right to confront the witnesses against you in open court and cross-examine through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes.
Now, under the Constitution, you have a right to use the power of the court in each case to compel or force witnesses to come into court to testify for you, just like the state. So if you have any witnesses that you're not certain in any of these cases are going to come in to testify, upon your request in that case, the court would issue a subpoena, which is a court order, that would force the witnesses in that case to come to court to be available to testify on your behalf, just like the state. And so this would apply in each of the cases, and you'd have the same right to get your witnesses to testify for you as the state does to get witnesses to testify against you. Do you understand that?
Yes.
Now, under the Constitution, in each of these cases, you have a privilege against self-incrimination, which means you cannot be forced to give evidence against yourself at any time in any of the cases. What that means, that means that you cannot be forced to testify by the prosecutor, the judge, or anyone else. It's up to you. If you decide not to testify in any or all of the cases, the fact that you did not testify cannot be used against you in any way by any person at any time in the case, and in fact, no one's even allowed to talk about it with one exception. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Now, in each of these cases, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense. So what that means is the burden of proof isn't on you in any of those cases to try to show you're not guilty. In fact, under the law, you don't have to present any evidence at all in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged in each case, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Right now, originally you entered a not guilty plea in each of these cases. That plea denied the allegations in each indictment, denied you committed any crime, and exercised or invoked all the rights that I've just described. Now, if you change your plea from not guilty to guilty in these three cases, that is the opposite of the not guilty plea. The guilty plea will admit the allegations in each indictment, admit that they're a crime, that you committed that crime. And that plea, in each case, would waive or give up all the rights I've described for you today except your right to have an attorney. Always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront the witnesses against you and to cross-examine them in open court through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. And it would waive or give up your presumption of innocence in each case, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court in each case. And finally, it waives, gives up any right to file an appeal that you think you may have had in any of these cases prior to today. Now, if I should sentence you to the maximum sentence or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes.
And are you a U.S. citizen?
Yes.
And did you enter into the agreement in each of these three cases voluntarily?
Yes.
All right, now do you have any questions about the charge in any of these cases or the possible penalties?
No.
You understand them?
Yeah.
Do you have any questions about the plea agreements?
No.
You understand them?
Yes.
Do you have any questions about the constitutional rights I've explained to you?
Yes.
You understand them?
Yeah, I understand them.
All right. Do you have any questions about the plea of guilty, what it means, what will happen?
Yes.
Okay, you understand that?
Yes.
Okay.
Sorry.
Now, do you need to talk with your attorney? I didn't tell you at the beginning of the hearing, but if you need to talk with your attorney or ask her any questions, I can let you do that at this point, put you into a breakout room where just you and she would be on the screen talking. The deputy would step out of the room so you'd be confidential. Do you need to talk to her about anything?
No.
All right. Then is it your decision to go forward and enter pleas of guilty to these three charges in these three cases pursuant to the plea agreement that I've just gone over?
Yes.
And then case number 22 CR 133, the reads in honor about the period of September 10, 2021 through December 24, 2021 in Highland County, Ohio. You did with purpose to deprive the owner, Laura Goolsby, DBA Ohio Helping Hands LLC, of their property, knowing they obtained and exert control over said property, to wit, U.S. currency $4,634.69, and other miscellaneous items without the consent of the owner or person authorized to give consent, value of the property being greater than $1,000 but less than $7,500, in violation of section 2913.02A3 of the Higher Revised Code, charge of theft, a fifth-degree felony, carrying possible penalty between 6 to 12 months in prison, fine of $2,500. How do you plead?
Guilty.
Then as to case number 23 CR 26, you know, I think I need to disclose something here. It just occurred to me. In that particular case, Ms. Goolsby, who owns the company, the cleaning company, they have a contract with the county to clean the buildings, including the courthouse. We don't hardly ever see her, although I did see her yesterday because she introduced a new employee, but that's the extent of it. I don't really feel in my mind that that is a conflict at all, but I just want to disclose it to see if counsel for the defendant feels there's any issue there.
I was aware of the contract. I didn't see it as a conflict, Your Honor.
All right, so if there is any conflict, you'd waive it.
Yes.
And you feel there is any problem there with me hearing that particular case? It doesn't apply in the other two cases, just in that case. You all right with that, Ms. Humphrey?
Yes.
Okay. All right. Like I said, we don't deal with her, but except that she did bring over the new employee yesterday. It's the first time I've seen her in, I don't know, years. Okay. Now, in case number 23 CR 26, that's the tampering charge, alleges on or about January 19, 2023 in Highland County, Ohio. You did, knowing an official proceeding or investigation was in progress, was about to be or likely to be instituted, did alter or destroy, conceal, or remove a record, document, or thing with the purpose to impair its value or availability as evidence in such proceeding or investigation in violation of section 2921.12A1 the Ohio Revised Code, a charge of tampering with evidence, a third-degree felony with a possible prison term between 9 and 36 months, a fine of $10,000. How do you plead?
Guilty.
All right, and then as to the third case, 23 CR 68, which alleges that on or about March 8, 2023 in Highland County, Ohio, you did recklessly fail to appear as required in Highland County Common Pleas Court, case number 22 CR 133, after having been released pursuant to ORC 2937.29, and the release was in connection with the charge of a commission of a felony, a violation of section 2937.99 of the Ohio Revised Code, charge of failure to appear, fourth-degree felony with a possible prison term of between 6 and 18 months and a fine of $5,000. How do you plead?
Plead guilty.
All right, thank you. All right, the court finds on this day in open court, the defendant was advised of all her constitutional rights and made a no intelligent voluntary waiver of the same pursuant to criminal 11. Plea is accepted and ordered filed. Defendant is found guilty in each case of the charge in that respective indictment. The matter is referred for a pre-sentence investigation to the probation department. Will require an assessment for substance use disorder, mental health, and a STAR assessment. Sentencing hearing will be on July 5 at 9 a.m. Bond will be continued in each case. All right.
Your Honor, Your Honor.
Yes.
They're actually in the 133 case. I know that it's moot at this point, but I think probably needs to be withdrawn. There was an ILC motion filed in an order for her to complete an assessment in that case.
Well, she never showed, so yeah, that matters moot. Yeah.
Well.
Yeah.
Thank you.
All right. Is there anything then further from counsel?
No, Your Honor.
All right. We'll have a sentencing hearing then on July the 5th, and the probation department will be in touch with you. Thank you. All right. Who we have up next at the jail?
Open.
All right, case number 23 CR 22, State of Ohio versus Avalon Rich. Are you Avalon Rich appearing there from the jail?
Yes.
All right, this hearing is being conducted by Zoom. It's a pretrial. Representing the state is Prosecutor Attorney Collins, representing the defendant's attorney Sarah Barger. Both appearing by Zoom. This defendant was indicted along with Dylan Harner in a 4-count indictment. Actually, she's charged in counts 1 and 2, receiving stolen property, 2 fourth-degree felonies. This is a first pretrial. Final pretrial is July the 5th, and the jury trial is set for July 13. All right, looks like that state did provide the bill of particulars and discovery. So your discovery will be due by the final pretrial, Ms. Barger. Now, do you anticipate any pretrial motions?
Not at this time.
All right, and is there a written plea offer?
Yes, Your Honor.
Is your client aware of it, Ms. Barger?
No, not yet.
Okay. All right. Are there any other matters we need to discuss at this time?
Not from the state.
No, Your Honor.
All right, then your next pretrial will be July the 5th, Ms. Rich. Thank you.
Your Honor, just for the record, the victims in this case.
Oh, I'm sorry. Thank you. You did notify them of the time, place, purpose of this hearing, and the right to be heard.
You'll note that the victim in one of the counts has opted out per the VRR, and then Rob's Exotic Cars was notified of the time, place, and purpose of this on, we were notified them on 5/26 of 23.
All right, thank you. All right. Amber Doctor. All right, are you Amber Nicole Doctor appearing from the jail?
Yes, sir. Or yes, Your Honor.
All right. This is case number 23 CR 65, State of Ohio versus Amber Nicole Doctor. This matter is a pretrial being conducted by Zoom. Her attorney is Dennis Kirk, who's appearing by Zoom, and the attorney, or the state is represented by a prosecuting attorney, Annika Collins. Now, Mr. Kirk, do you and your client both agree to this matter being conducted by Zoom rather than a personal appearance here before the court?
Yes, Your Honor.
All right, and you're all right with that, Ms. Doctor?
Yes, Your Honor.
Now, at any time, if you need to talk to your attorney, ask any questions, or talk to him about anything that you have concern about, just tell me, and I can put the two of you into what's called a breakout room. It will be just the two of you on the screen talking, and no one else will be able to see you or hear you on the screen, and the deputy will step out of the room during that time so that your consultation is confidential.
Okay.
You understand that?
Yes.
Okay. Now, Ms. Doctor is charged in a 6-count indictment. It looks like 3 counts of aggravated trafficking in fentanyl-related compound in a school zone, and 3 counts of aggravated possession of a fentanyl-related compound. I believe this is a final pre-trial, and the trial date is July the 10th. Now, I've been presented with a plea of guilty form, which indicates that you're going to withdraw your not guilty plea and plead guilty to counts 1 and 3, 4th and 3rd degree felony. I'm going to show you the first page of that document, cover sheet, so to speak. You recognize it has your name and case number and says you're pleading guilty to those 2 charges?
Yes, sir.
On page 3, there are signature lines. About halfway down, there's a sentence that reads, I enter this plea voluntarily. Right below there is a signature of defendant line, and is that your signature on that line?
Yes, Your Honor.
And when did you sign this agreement, Ms. Doctor?
It was a couple days ago.
All right. Before you signed it, did your attorney go over it with you and explain everything to you and answer any questions you had?
Yes.
When you signed it, did you understand it was agreement to plead guilty, which means there's not going to be a trial, and the next step of your case would be a sentencing hearing?
Yes.
Did you think that you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And it's been a couple of days ago. Do you still want to go forward with this today?
Yes.
And did you sign this agreement voluntarily, and you're agreeing to go forward today voluntarily?
Yes.
All right, now, the agreement states you're going to plead guilty to counts 1 and 3. Count 1, aggravated trafficking in a fentanyl-related compound in the vicinity of a school zone under 2925.03A1, a 4th degree felony, and then count 3 is the same charge, same section number, but it's a 3rd degree felony because of an additional allegation. It states that you understand that on page 1, it states you understand that count 1 carries a prison term possibility of between 6 and 18 months, and a fine of $5,000 and a license suspension of 6 months to 5 years. Count 3 is a 3rd degree felony, carries a possible prison term between 9 and 36 months in certain levels that are provided by the statute. It goes 9, 12, and then every 6 months up to 36 months. There's a fine available $10,000, and that one there's a mandatory fine of $5,000, and also a license suspension of 6 months to 5 years. Now, do you understand that?
Yes. Yes.
Now, if you are convicted of both offenses, and if you should be sentenced to prison for both offenses, those sentences can be ordered to be served consecutively to one another, meaning one after the other. So if you add those 2 together, 18 months maximum on count 1, 36 months maximum on count 3 means the maximum possible prison term is 54 months, and the maximum fine is $15,000. Do you understand that?
Yes, Your Honor.
Now, other than these charges, are you facing any felony charges in any other jurisdiction?
Yeah, Fayette County, but they told me that they would go with whatever they're doing here.
Okay. Well, if at some time you should be sent to prison in each case, from each county, those sentences could be ordered to be served consecutively, meaning one after the other. So whatever Fayette County might impose could be served on top of what the court here imposes. You understand that?
Yes, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
No.
All right, now under the law, if you are convicted and if you are sentenced to prison for this offense, then upon completion of that prison term, the Adult Parole Authority has the option, if they choose to exercise it, to put you under post-release control supervision for a period of up to 2 years under terms they set. And if during that period of time they determine that you have not complied with those, they could return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony while under post-release control, then in addition, whatever sentence could be imposed by the judge in that new case, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively the sentence in the new case. Do you understand all of that?
Yes, sir.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called non-prison or community control sanctions, which means instead of going to prison, you'll be put under the supervision of a probation officer on the term set by the court for a period of up to 5 years. If during that period of time the probation department felt you were not complying, they would file a written notice of that with the court. You would get a copy. There would be a hearing. You'd be entitled to have an attorney. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for 54 months and fine you the $12,500, or I'm sorry, $15,000. You understand that?
Yes.
All right, now, the charge in count 1 alleges that on or about June 7, 2022 in Highland County, Ohio, Jeremy Joseph Wilson and you did knowingly sell or offer to sell a fentanyl-related compound, Schedule 2 controlled substance in the vicinity of a school zone, in violation of Section 2925.03A1. So that's the 4th degree felony. Count 3 alleges that on or about June 8, 2022 in Highland County, Ohio, Jeremy Joseph Johnson and you did knowingly sell or offer to sell a fentanyl-related compound, a Schedule 2 controlled substance, an amount equal to or exceeding 1 gram but less than 5 grams in the vicinity of a school. And that's the 3rd degree felony with a possible prison term between 9 and 36 months and a fine of $10,000. And each of them carry a possible license suspension of 6 months to 5 years. Now, Ms. Doctor, do you understand what it is you've been charged with in each of those cases, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
Have you discussed the nature of each charge, the evidence in the case, possible legal issues in the case, possible defense you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty in this case?
No.
At the bottom of page 2, there are several lines printed in bold and underlined, which read as follows. Defendant shall under plead guilty to count 1, count 3. State will dismiss remaining counts. State and defense jointly recommend community control and substance abuse treatment. Defendant agrees to pay back and buy money to the Highland County Task Force in the amount of $650, joint and several with Jeremy Joseph Wilson. Defendant agrees to cooperate fully in prosecution of the co-defendant. Defendant agrees to cooperate fully with the task force. Now, is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Under the law, the matter sentence is up to the judge, not the parties. And so in the event that you plead guilty, once all the information is presented at the sentencing hearing, it could be that instead of getting a community control or probation, you would be sentenced to prison for as much as 54 months. You understand? And fined $15,000 and have your license suspended for 6 months and 5 years. Do you understand that?
Yes.
Right now, you have, or do you hold any license or certification from any state governmental agency that regulates any occupation in a state?
No.
All right, now you have certain rights you must understand before I can accept a plea from you. First, you have a right to have an attorney, and I appointed Mr. Kirk to represent you. Now, that wasn't simply to work the case out, but to provide whatever defense might be available to you under the law that you would like him to provide. So, if you decide that you do not want to do this, that you would rather defend the case, he'll continue to represent you, be your lawyer, and defend you, including a trial if that's what you want. Do you understand that?
Yes.
Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and the jury would be instructed on the law. And then the jury of 12 people would have to decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proves your guilt. If you didn't want to have jury trial, but you didn't want to plead guilty, you can waive, which means to give up in writing, your right to have a jury trial. And in that case, you would have what's called a quarter bench trial, meaning instead of the jury, it would be the judge that would hear the evidence, apply the law, decide whether or not the state proves your guilt. Do you understand that?
Yes.
Now, under the Constitution, you have a right to use you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into the courtroom and testify in front of you and your attorney and anyone else who may be present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that? Do you understand that?
Yeah.
All right, now under the Constitution, you have a right to use the power of the court. Hold on a minute. All right, ma'am, the person that's on the screen identified as PL571, if you would please mute yourself because you're getting sound that's interfering with this hearing. All right, I think I muted her. Nope. Did you hear me, ma'am? PL571, you need to mute your audio button. Go down and press that little button and it'll say mute. Press that because your background sound's coming through your microphone. All right, there we go. All right, thanks. All right, so you have the right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, your request, court issues a court order, and that would force them to come to court to testify on your behalf, even though they don't want to be here, which is the same way the state's witnesses come to court to testify against you. Do you understand that?
Yes.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can, you make the decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Now, under the Constitution, you are presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense by proof beyond a reasonable doubt. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof stays upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives or gives up all the rights that I've described for you today, except the right to have an attorney, which you always have no matter what your plea. But with that exception, your plea of guilty will waive or give up your right to a jury or court trial. It'll waive or give up your right to confront witnesses against you and to cross-examine through your attorney. It'll waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It'll waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. And it waives or gives up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
All right. Now, you have any questions about the charges or the possible penalties?
No, Your Honor.
You understand?
Yes.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
Any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
You understand it?
Yes.
Now, is there anything you'd like to speak to your attorney about before we go any further? If there is, you can speak with him on a breakout room where no one else will be able to hear you, see you, the deputy would step out.
No, I'm okay.
All right. You have any questions at all?
No.
Then is it your decision to withdraw your not guilty plea, plead guilty to counts 1 and 3 pursuant to the terms of the agreement that I've just gone over?
Yes, Your Honor.
All right, then as to count 1, which alleges that on or about June 7, 2022 in Highland County, Ohio, Jeremy Joseph Wilson and you did knowingly sell or offer to sell a fentanyl-related compound and scheduled food controlled substance in the vicinity of a school, violation of section 2925.03A1, charge of aggravated trafficking of fentanyl-related compound in the vicinity of a school zone, a 4th-degree felony, carry possible prison term between 6 and 18 months, a fine of $5,000, a license suspension of 6 months to 5 years. How do you plead?
Guilty.
And then count 3, which alleges on or about June 8, 2022 in Highland County, Ohio, Jeremy Joseph Wilson and you did knowingly sell or offer to sell fentanyl-related compound, a Schedule 2 controlled substance, an amount equal to or exceeding 1 gram, less than 5 grams, in the vicinity of a school zone, a 3rd-degree felony carrying a possible prison term between 9 and 36 months, a fine of $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right. The court finds that on this day, in open court, the defendant was advised of all of her constitutional rights and made a knowing and intelligent voluntary waiver of the same pursuant to Criminal Rule 6. Criminal Rule 11. The defendant is found guilty of counts 1 and 3 as charged in the indictment. Counts 2, 4, 5, and 6 are dismissed as to this defendant. The matter is referred to the Probation Department for a pre-sentence investigation that will include an assessment for substance use disorder and or mental health treatment. Sentencing will be on July the 5th at 9 a.m. and bond will be continued. Now, I know there was a request for an OR bond, but in as much as this has happened, and I think treatment is one of those things, the court would consider that being to a treatment facility if she is admitted into one prior to sentencing. So I'll defer ruling on your motion at this time, Mr. Kerr.
Okay, thank you, Your Honor.
All right. Now, is there anything further from counsel? All right.
No, Your Honor.
All right, thank you. All right. Is that Ms. Throckmorton on PL 57? Throckmorton on PL 571, if you are, would you please unmute yourself?
I'm not.
I know you're not. I'm talking to a woman that's on another screen who's rocking back and All right, case number 23 CR 83, State of Ohio versus Sandy Throckmorton. Ms. Throckmorton is appearing on the screen marked PL 571. This is a Zoom hearing. Her attorney is Dennis Kirk, appearing by Zoom and appearing from the prosecutor's office, Prosecuting Attorney Collins. Defendant is charged with 1 count of aggravated possession of methamphetamine, a 5th-degree felony. This is a final pretrial, I believe. No, first pretrial. I've received a motion for intervention in lieu of conviction, and I do have this stipulated questions. And so the court will order that the matter be referred for a report and an assessment. Ms. Throckmorton, you'll need to contact the probation department about being assessed for admission into a treatment program, because that's a requirement for you to participate in this program, which would allow you to avoid a felony conviction if you successfully complete that treatment. So go ahead and contact the probation department as soon as you get done. Sign out and contact probation, okay? We will set this for hearing on, we'll set it for July the 5th at 11 a.m. All right, anything further, counsel? All right.
No.
You can go ahead and sign off, Ms. Throckmorton. Thank you.
Thank you.
All right. Nicole Jacqueline Pierce. All right, case number 23 CR 69, State of Ohio versus Nicole Jacqueline Pierce. Now, are you Nicole Jacqueline Pierce appearing there from the jail?
Yes.
All right. This is a pretrial being conducted by Zoom. The defendant is appearing from the jail. Her attorney is Danielle Witt, appearing from her office, appearing from the prosecutor's office, Prosecuting Attorney Collins. The defendant is charged with felonious assault and assault. This is a final pretrial, and trial is set for July the 10th. Now, I have been presented, Ms. Pierce, with a plea agreement. Well, first of all, Ms. Witt, do you and your client both agree to waive her presence in the courtroom and allow this matter to be conducted by Zoom?
Yes, we do.
And Ms. Pierce, you're okay with that?
Yes.
Ms. Pierce, are you all right with that?
Yes.
All right. Now, the court has received a plea of guilty form, which indicates that, well, let me back up. Since you're not sitting in court next to your attorney, if at any time you decide you need to talk to her or ask her any questions, you just tell me and I can put the two of you in a breakout room, and you'll be able to talk to her without anyone seeing or hearing you on the screen, and the deputy will step out of the room that you're in so that you can speak with her in confidence. Okay?
Okay.
All right. Now, I've been presented with a plea agreement form, which indicates you're going to plead guilty to the indictment. And I'm going to hold up the first page and show that to you. And it has your name and case number and says you're going to plead guilty. You see that page?
Yeah.
Did you recognize that page and seen that agreement before?
Yes.
All right. On page 3, there's signature lines. And at the bottom of the page, there's a sentence. The last sentence reads, "I enter this plea voluntarily." Below that appears to me to be signature Nicole Pierce. And I'm going to hold that up to the camera and ask you if that is your signature there.
It is, yes.
When did you sign this document, Ms. Pierce?
This morning.
When you signed it, did you understand it was an agreement to plead guilty, meaning there's not going to be a trial, and the next step would be a sentencing hearing?
Yes, I did.
And did you have her go over it and explain everything to you and answer any questions before you signed it?
Yes, I did.
And did you have enough time to fully consider this matter before making this decision?
I did, yes.
Do you feel you've been rushed or pressured in any way into doing this?
I have not.
And did you enter into this agreement voluntarily?
Yes.
Now, the agreement states on page 1 that you're going to plead guilty to count 1, which is felonious assault, under 2903.11A2, a second-degree felony, and count 2, assault, under 2903.13A of the Higher Revised Code, a first-degree misdemeanor. States that you understand that is to count 1. All right, Ms. Leith, you're going to need to. I'll just try to mute her. Okay, thank God I got that done. All right, now, okay, count 1, the possible sentence to be imposed by the court is a minimum of between 2 and 8 years. And that is the sentence that, if imposed, is the minimum. And because under the law, for felonies of the first or second degree, whatever sentence a judge imposes can be extended by the Department of Rehabilitation and Corrections if they decide that that should be done for up to 50% of the term imposed by the judge. Therefore, since the maximum penalty is 8 years, it could be imposed by the court if you're convicted. That could turn into a 12-year sentence, depending upon the DRC. Do you understand that?
Yes.
All right. Now, are you facing any? Okay, on count 2, that's a misdemeanor, and it carries a possible 180 days in jail and a fine of $1,000. And under the law, if you're sentenced to custody in each of the cases, the misdemeanor has to run concurrent to the felony in this case. Do you understand that?
Yeah.
Now, are you facing any felony charges anywhere else?
No, I'm not.
Are you currently on community control, probation, parole, or post-release control for a felony?
No.
All right. Now, under the law, it's not mandatory that I sentence you to prison for these offenses, or for count 1. I don't have to sentence you to prison. So I could, instead of sentencing you to prison, impose what's called community control or probation. That means you'd be supervised by a probation officer for a period of up to 5 years on a term set by the court. If during that period of time probation department felt you were non-compliant, they would file written notice of that with the court. There would be a copy given to you. There'd be a hearing. You'd be entitled to have an attorney. If the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control, then sentence you to the prison for the 2 to 8 years and fine you $15,000 and give you 180 days in jail and fine you $1,000 on count 2. Do you understand that? I'm sorry, I didn't hear you.
Yes.
Okay.
Yes.
Now, if you should be sentenced to prison and serve a prison term, once you complete that prison term, it is mandatory that you be put under post-release control supervision by the Adult Parole Authority for a period of at least 18 months up to a maximum of 3 years. So what that means is that a probation officer or a parole officer will supervise you under the term set by the APA, because the court has nothing to do with that. If during that period of time they determine that you've not complied, then they can return you to prison even though you served the entire term set by the court for an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. But if you commit a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time was left on that post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes.
All right. Now, the charge in count 1 reads that on or about March 11, 2023 in this county, you did knowingly cause or attempt to cause physical harm to Kyle Krebs by means of a deadly weapon as defined in ORC section 2923.11a or dangerous ordinance, to wit a fixed blade knife. And in count 2 alleges on or about March 11, 2023 in Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to RC in violation of section 2903.13a of the Higher Revised Code. Now, do you understand what it is you've been charged with in that those 2 counts, what the state said you did, when, where, and how they led you did it?
Yes.
All right, and before we go any further, Ms. Collins were the victims of the alleged victims of the offenses informed of the hearing, the purpose and time and place of it, and the right to be heard?
Yes, the victim of the felony we've been in contact with him throughout. He has chosen not to appear any hearings, however, did approve the plea agreement, and thinks that mental health treatment after a term of punishment is what the defendant needs. The victim of the misdemeanor, his mother is present, as well as her representative. My understanding is they do not wish to speak. They have been notified of the plea agreement and that the sentence of the misdemeanor would run concurrent with the sentence for the felony. Thank you.
All right, thank you. All right. Now, have you consulted with your attorney regarding the charges, the possible legal issues, the possible defenses you might try to raise at trial, possible outcomes of a trial, and then possible outcomes of a trial with your attorney?
Yes.
And are you satisfied with her advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Are you taking any prescription drugs?
No.
Have any threats been made to make you plead guilty?
No.
Now, on page 3, at the top of the page, there's 3 sentences that are printed in bold and underlined, which I'll read at this time. Defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend 4 years incarceration on count 1, concurrent to 180 days on count 2. State will not oppose judicial release to Starr after 2 years incarceration. Is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty?
No.
Now, under the law, the matter of sentence is up to the judge. The parties cannot set the sentence. That is up to the judge. So, once I've heard all the information presented, if you plead guilty to these charges, I could follow it or I may not. I could end up deciding that's not the correct sentence, and I could sentence you to anywhere between 2 and 8 years on count 1, plus a fine of $15,000. Do you understand that?
Yes.
All right. Now, do you hold any kind of a license or certification from any state governmental agency that regulates any occupation or professions in this state?
No.
All right. Now, you have certain constitutional rights you must understand before I can accept your plea. First, you have a right to have an attorney. Ms. Witt was appointed to represent you. That wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you would like her to provide. So, if you decide that you do not want to plead guilty, that you want to defend against these charges, she'll continue to represent you, including a trial, if that's what you want. You understand that?
Yes.
Under the Constitution, you have the right to have a jury trial in this matter in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 are selected, the evidence is presented, they're instructed on the law, and then that jury has to decide by unanimous verdict, I mean all 12 of them would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means to give up your right to have a jury trial. In that case, you would have what's called a quarter bench trial. And that means instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes.
Under the Constitution, you have a right to confront witnesses against you in open court and cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. You understand that?
Yes.
Under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order to subpoena, and that forces those people to come to court to be available to testify, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. You understand that?
Yeah.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence against yourself in this case at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. If you decide not to testify, the fact that you did not testify in this case cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that caused that issue right, they cannot consider it for any purpose. Do you understand that?
Yes.
Now, under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence in your own defense at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Right, now, originally you entered a plea of not guilty to this offense, both offenses. The not guilty plea denies allegations in the indictment, denies you've committed any crime, and it exercises or invokes all the rights that I've just described for you, except your right to have a jury trial. You always have a right to have a jury, your right to have an attorney. You always have a right to have an attorney no matter what your plea. But other than that, your plea of guilty will waive or give up your right to a jury or court trial. It will waive or give up your right to confront witnesses against you and cross-examine through your attorney. It will waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It will waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. And it will waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up your right to file an appeal on any alleged violations of your rights you feel may have occurred up to this point. Now, if I should sentence you to the maximum sentence, or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. You understand that?
Yes.
And are you a U.S. citizen?
Yes.
And you've entered into this plea agreement voluntarily?
Yes.
Now, do you have any questions about the charge or the possible penalty?
I don't.
You understand them?
Yes.
All right, just a second here, excuse me. Get a hold of Catherine and have her, I know she's on Zoom right now, or check the calendar, see you here tomorrow, or Friday, because this Leith woman, I'm gonna have to hear her. She's hired tonight. All right. So your plea of not guilty exercised all the rights I've explained. If you change your plea from not guilty to guilty, that waives or gives up all those rights except the right to have counsel. You always have a right to have an attorney no matter what your plea, as I explained to you. Now, you understood all of the things that I explained to you already?
Yes.
All right, you have any questions about the charge and the possible penalties?
I don't.
And you have any questions about the plea agreement?
No, I don't.
And I don't know if I explained this to you or not. I think I did, but I'll go back and just make sure. Is that under the law, the matter of sentence is up to the judge. I don't have to grant, I don't have to follow a sentence recommendation, and I don't have to grant judicial release simply because it's being recommended after 2 years. You understand that?
Mm-hmm.
Okay. You have any questions then about your constitutional rights?
No.
You understand them?
Yes.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes.
All right. Is there anything you'd like to speak to your attorney about before we go any further?
No. I spoke with him.
Do you have any questions at all?
No.
All right. Contact her. Yeah, I'll text her and ask her if she's going to be around tomorrow, because I'm going to move that Leith case back because she's on. Okay. I want to move it to in person. All right. Then it's your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of this plea agreement.
Yes.
Then as both charges, I should say. All right. As to the first count, which alleges that on or about March 11, 2023 in Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to Kyle Krebs by means of a deadly weapon, is defined in ORC 2923.11a, or dangerous ordinance, to wit, a fixed blade knife in violation of section 2903.11a2, charged with felonious assault, a second-degree felony, carrying a possible prison term of between 2 and 8 years as a minimum set by the judge, with the possibility of that being extended by up to 50% or 1/2 by DRC. A fine of $10,000. How do you plead?
Guilty.
I'm sorry, $15,000. You plead guilty?
Mm-hmm.
Okay. As to count 2, which alleges on or about March 11, 2023, in Highland County, Ohio, you knowingly attempt to cause physical harm to RC, violation of section 2903.13a, a first-degree misdemeanor carrying a possible jail sentence of 180 days and a fine of $1,000. How do you plead?
Guilty.
All right, thank you. The court finds on this day in open court, defendants advised of all their constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11. Please accept and order filed. Defendants found guilty of each count as set forth in the indictment. All right, and inasmuch as there is a jointly recommended sentence, and due to the nature of these charges, the court will not order a pre-sentence report, but instead will proceed with sentencing forthwith. Ms. Collins, anything on behalf of the state?
Only what's contained within the plea agreement, Your Honor.
And neither of the victims wish to be heard?
No, Your Honor.
All right. Ms. Witt?
Yes, Your Honor. We also asked the court to follow the joint recommendation. Nicole's only other prior felonies was about 18 years ago in 2005, and feel that this sentence is adequate.
All right, Ms. Pierce, anything you would like to say?
No.
All right. And it's ordered of the court that you be and are hereby sentenced to the Ohio State Reformatory for Women, Marysville, Ohio, for a period of 4 years. According to the sheriff, you were taken into custody on March 11th. Is that correct?
Yes.
All right, so you'll be given credit from March 11th to today, which is a total of 88 days. Now, upon completion of this sentence, it is possible that the Adult Parole Authority, it is mandatory that the Adult Parole Authority put you under post-release control supervision for at least 18 months, up to a maximum of 3 years. During that period of time, you'll be supervised by a parole officer on the terms they set, and if they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of 1/2 of your prison term for all violations. But if you commit a felony, then in addition to whatever sentence the judge in a new case can impose upon you, the judge could also sentence you to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater, and if that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which Judge Brandi executes as ordered. If you fail to pay those costs, then the clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then after you complete your prison sentence, not while you're in prison, the court would permit you to do community service in this county and give you credit for each hour you worked. In an hourly rate set by the court, each hour you work, reduce your judgment by that amount until paid in full. And there's no restitution was requested, Ms. Collins?
No, but you didn't sentence her to the misdemeanor.
No, I did not. Yeah. All right. Now, you're also ordered to serve a sentence of 180 days in the Hynek's County Jail, and that is required by law to be served concurrently. So the 2 years you're serving will include that 180 days.
Thank you.
All right. Anything further from counsel?
No, Your Honor.
All right. You're remanded to custody then, Ms. Pierce. All right. Robert. All right, are you Robert Taylor appearing from the jail?
Yes, yes, sir.
All right, this is case number 23 CR 81, State of Ohio versus Robert Keith Taylor. It's a Zoom pretrial. Mr. Taylor is appearing from the jail. His attorney is Catherine Hafner, appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. Defense charged with 3 counts of rape. This is the first pretrial. I believe the final pretrial may be July the 5th, and we have a trial date, I believe, later in July 24th. I see that the state has provided discovery, and let's see, I think there was a bill. And did you also provide a bill or a bill of particulars, Ms. Collins?
Yeah, we filed a notice that we provided it
Here
on.
it is. I see it. Yeah, I found it there. All right. You received both of those, Ms. Hafner? You're muted, Ms. Hafner. Ms. Hafner, you're muted?
Yes,
Oh,
I
okay.
did receive both those.
All right. You,
And
go ahead.
I was just gonna say, I've also received a plea offer, and I've given my client his copy of discovery and the plea offer.
All right. Are you anticipating any pretrial motions?
No motions at this time, except that I did notify my client that I'm not available on the scheduled trial date, and he said he has no issues with waiving time so that we can reschedule that if necessary.
Okay. Well,
So I do
you,
anticipate filing a motion to continue if needed.
all right, if you do, please get the written waiver, and then we can do that.
Sure.
All right. Okay. Any other matters need to be discussed at this time on this case?
No, Your Honor.
The victim's guardian was notified of the hearing. She also knew of her right to attend and elected not to.
Okay. All right. And if there is a continuance request, we'll have to notify her too. So you'd need to try to get that in pretty quickly, Mrs. Hapner, so we can comply with that.
Okay.
Yeah, thank you. All right. Next from the jail will be Donald Hill. But I want to go ahead and do Miss Leith now. Miss Leith, if you can hear me, where's her file at? All right, this is case number 23 CR 85, State of Ohio versus Catherine Leith. And Miss Leith is appearing on the strain mark Catherine Leith. Her attorney is Catherine Hapner, appearing from her office, and appearing from the prosecutor's office is Prosecutor Collins. This is a Zoom hearing being conducted. Miss Leith looks like she's in her car. Miss Leith is charged with one count of aggravated possession of fentanyl-related compound, a fifth-degree felony. This is the first pretrial. Final pretrial is July 5. Trial date is July 24. Now I see that the discovery request was just made this morning, so that's just what's been filed. Is there anything else that we need to discuss then at this point?
I don't think so, Your Honor.
All right. Miss Leith, I'm looking at a fax that I received from the probation department that indicates that they've had a bed schedule for you for 4 different times for treatment. You've been testing positive for meth and fentanyl and amphetamines and ecstasy and pot. And you were there this morning and you're supposed to be transported, but you said you didn't have your stuff, you couldn't leave. You were going to go back, you're supposed to be going there. Are you planning on going to the counseling center?
I told him that I did. I told him I did not have my stuff, and yes, day one's on their way to get me, and I had to go get my stuff. I've had a lot of trouble with my stepdad in the last few days trying to get my stuff, but I'm headed there now to get it, and day one's on their way to get me. They're already halfway en route.
All right, Mr. Arjima, what do you want to do about that situation?
Ms. Sturgill said that she talked to TCC and they are willing to take her. I didn't know that they were coming to get her.
Yeah, I called them as soon as I left your office, and the lady that come and picked me up, she's taking me to get my stuff now, and I called Ryan at day one, and he called transportation, and they're coming to get me.
The counseling center?
I'll be there by the end of the day.
All right, good. Well, you do that because that's been their recommendation. That's a requirement of bond. All right. Okay. You can go ahead and sign off. Thank you.
Thank you.
I need Donald Hill. Are you Donald Hill? Case number 23 CR 82, State of Ohio versus Donald Hill. This is a hearing, a pretrial hearing being conducted by Zoom. Mr. Hill is appearing from the jail. His attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office is Prosecuting Attorney Collins. The defendant is charged with 5 counts of sexual battery. This is the first pretrial. Final pretrial is July 5. Trial date is July 24. See this? There has been discovery filed in the case by the state, request for the state. So your discovery will be due by the final pretrial, Mr. Armentrout. Do you anticipate any pretrial motions?
No, Your Honor.
Has there been a written plea offer received?
There has. He's got his discovery and he's got the plea offer.
Okay, all right. Are there any other matters then that need to be discussed at this time?
No.
Yes, Your Honor. We've been in close contact with the victim. She was aware of the hearing and elected not to appear today.
All right, thank you. Still trying to get adjusted to Marcy's law. All right, thank you. Is that the last one in jail?
Yes, Your Honor.
All right, thank you then. I guess we're done with the jail. All right, now, case number 23, CR 77, State of Ohio versus Reese Fist. Ms. Fist is appearing from the probation department by Zoom. This is a pretrial. Appearing on behalf of the state is the prosecuting attorney Collins. Appearing on behalf of the defendant is attorney Danielle Witt. The defendant is charged with 6 counts of endangering children. Is there a victim representative involved in this case, Ms. Collins?
It's the guardian of the children, but she is aware of the hearing and has chosen not to attend.
All right, and she's been informed of the purpose, time, place, and purpose, and the right to be heard?
Yes.
All right. I see that the state has provided discovery and a bill of particulars, and you've received that, Ms. Witt?
Yes, Your Honor.
All right. You'll be required to provide discovery by the final pretrial. Do you anticipate any pretrial motions?
No, none at this time.
All right. And is there a written plea offer in this case yet?
There is.
Defendant,
Yes, Your Honor.
Is the defendant aware?
Not yet. I need to get her contact information.
Okay. All right. He's in custody, I believe, so. Oh, no, he's not in custody.
Reese is a girl, Your Honor.
She, I'm sorry, yeah. I was looking at another file. All right. All right, so Ms. Fist, do you give your attorney your contact information there? Phone number?
I can give her my contact information if we're in a separate room or however.
All right, well, here's what you do. You call her. You want to give her your number, Miss Witt?
Yes. It's 937-393-3487.
Okay.
All right. Thank you. All right. Dennis Sears. Conducted by Zoom. Defense charged with assault on employee of a local correctional facility. His attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office is Prosecutor Collins. Is the victim present or been notified of the time, purpose, and place of this hearing and the right to be heard?
He has, Your Honor, and has elected not to participate.
All right. So this is a final pretrial. Trial is set for July the 10th. Looks like discovery has been completed. Is there any additional discovery that either side's aware of at this time?
No, Your Honor. I think we'll resolve this matter, but Dennis, I need you to come in and watch that video, maybe sometime tomorrow if that's possible.
We'll try to make that.
Call me right after this hearing if you would, please.
Okay.
If you give him a call, Mr. Sears, after we're done here and get a definite time, because just trying to do it is not going to be enough. So you need to make sure you get it done. All right?
Yes, sir.
Okay. Anything else we need to discuss on this case?
No, Your Honor. Thank you.
All right. Thank you. All right. You can sign off then, Mr. Sears. All right. The man that's appearing on the screen. All right, this is case number 23 CR 88, State of Ohio versus Robert Dwayne Throckmorton Jr. Mr. Throckmorton is appearing by video. This is a Zoom hearing. And are you at the counseling center?
I'm at First Capital in Chillicothe.
Oh, First Capital, Chillicothe, okay. Mr. Throckmorton's attorney is Danielle Witt, appearing from her office. Appearing from the prosecutor's office by Zoom is Prosecutor Collins. Defendant's charged with aggravated possession of methamphetamine, a 5th-degree felony. This is a first pretrial. Final pretrial is on July 5, and I believe the trial date is August 2nd. I see the state's provided the discovery bill of particulars, so defense discovery will be due by the final pretrial. Do you anticipate any pretrial motions, Ms. Witt?
Not at this time.
And has there a written plea offer that's been received?
There has been.
Is your client aware of it yet?
He is not. I also need to get his phone number.
All right, can you give us a contact number there for your attorney?
Yes, sir. It's 740-935-8852.
Okay. Is that your direct number, or is
Yeah,
that
that's my personal cell phone.
Okay, I will be in touch.
All right, you go ahead and sign off then, Mr. Throckmorton. Thank you.
All right, thank you, sir.
All right, the folks that are on the screen mark Kendra Ward, if you'd identify. Oh, by the way, we have a couple of in-person hearings. What's your name, sir?
Philip Linehan?
Mr. Williams is present in the courtroom. And then Mr. Johnson, he's supposed to be present. I haven't. Okay. Well, she's not on here. Ms. Hapner, have you heard from Mr. Johnson?
I have not.
Okay, well, we'll have to do him in person and here.
He's here in the office.
Oh, he's at your office? Oh, okay. Well, then get him on the screen. We'll do him next. All right. This is 23 CR 49, State of Ohio versus Kendra D. Ward. And you're Kendra D. Ward, appearing on the screen there, Mark Kendra Ward.
Yes, sir.
All right. Ms. Ward's attorney is Catherine Hapner. This hearing is being conducted by Zoom. Ms. Hapner is appearing from her office. Appearing from the prosecutor's office by Zoom is Prosecuting Attorney Collins. And this looks like we have a plea form in this case. Now, Ms. Hapner, are you and your client both agreeable to this hearing being conducted remotely using Zoom rather than an in-person appearance in the courtroom?
Yes, we are.
And you're all right with that, Ms. Ward?
Yes.
All right, now if any time during this proceeding you need to talk with her, just let me know and I can put you into a breakout room where you'll be the only two on the screen, and the gentleman there to your right can step out while you talk with her confidentially, okay?
Thank you.
All right. Now, the defendant is charged with failure to comply with the order signal of a police officer, a third-degree felony, aggravated possession of fentanyl, a fifth-degree felony, and aggravated possession of methamphetamine, a fifth-degree felony. This matter is set for trial on July the 12th. I have been presented, as I said, with a plea of guilty form. I'm going to hold this up, the front page of that, to the screen and see if you recognize that first page.
Yes, Your Honor.
All right, and that's the cover sheet, the first page of the agreement. The third page, about a third of the way down, there's a sentence that reads, "I enter this plea voluntarily." Immediately below that is a signature that I can actually read, Kendra Ward. Is that your signature there?
Yes, sir. Yes, sir.
All right. When did you sign that document?
On the 5th.
All right. And had you been in contact with your attorney to discuss this matter and discuss the terms and what it meant?
Yes.
And did you feel you had enough time to fully consider this matter before you made this decision?
Yes, Your Honor.
And did you enter into this agreement voluntarily?
Yes.
And since it's been a couple of days ago, do you still wish to do this?
Yes, Your Honor.
All right, the agreement says you're going to plead guilty to count 1, failure to comply with the order signal police officer under 2921.331B, a third-degree felony. Further states you understand the maximum prison term for that is between 9 and 36 months. There's a fine available of up to $10,000. There is a mandatory license suspension of at least 3 years up to life, although you can get driving privileges. And there is, if there's any other felony conviction, this would have to be served consecutively. Do you understand that?
Right. Yes, Your Honor.
And are you facing any felony charges anywhere else?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
Just pre-sentencing and probation.
Yeah, but just pre-trial, right? Okay.
Yeah.
Now, under the law, if you are convicted of this offense and if you should be sentenced to prison, once you complete the prison term, it is mandatory that you be put under post-release control supervision for a period of at least 1 year up to a maximum of 3 years. That means you'll be supervised by a parole officer on a term set by the Adult Parole Authority, and if the parole authority determines that you've not complied with those conditions, they can return you to prison to make you serve an additional period of up to 9 months for any single violation, but there is a cap or limit of half of your prison term for all violations. However, if you're convicted of a new felony while under post-release control, then in addition, whatever sentence could be imposed by the judge in that new case, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, Your Honor.
Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or non-prison sanction. That means instead of going to prison, you can be put under supervision of the probation department on a term set by the court for a period of up to 5 years. If during that period of time they felt that you're not compliant, they could return you or could notify the court of that in writing, give you a copy. There would be a hearing. You'd be entitled to be represented by an attorney. If the outcome of that hearing was that you failed to comply, then the court at that time could sentence you to 36 months and fine you the $10,000. You understand that?
Yes, Your Honor.
How are we doing on July the 5th of sentencing? So we got a lot. Can you check the schedule?
Yes.
Now, the charge in count 1 alleges that on or about February 20, 2023 in Highland County, Ohio, you did operate a motor vehicle as I've defined in ORC 4501.01, so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring a person's motor vehicle to a stop, and the operation of the motor vehicle by the offender causes substantial risk of serious physical harm to persons or property in violation of section 21.331B. That's the third-degree felony with the penalties I just described. You understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, Your Honor.
You understand the possible penalties.
Yes, Your Honor.
Have you discussed the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, Your Honor.
Yeah, and are you satisfied with their advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types or drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to make you plead guilty here today?
No, Your Honor.
Now, on page 2, there are a couple of lines toward the bottom portion that read as follows. They're printed in bold and underlined. That read as follows. Defendant shall plead guilty to count 1. State will dismiss remaining counts. State and defense jointly recommend community control, substance abuse, and treatment. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
And under the law, the matter of sentence is up to the judge, not the parties. So even though there's an agreement that that's what the sentence ought to be, the court's not bound by that. So if you plead guilty, once I've heard all the information submitted, if I decide that that's not the correct sentence, I could impose a prison term of up to 36 months and fine you $10,000. You understand that?
Yes, Your Honor.
All right. Now, do you hold any license or certification from any state governmental agency that governs any occupation or profession in Ohio?
No, Your Honor.
You have certain constitutional rights. You must understand before I can accept a plea. First of all, you have a right to have an attorney, and I appointed Ms. Hapner to represent you. That wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So if you decide you do not want to enter into this agreement, that you would rather defend against a charge, you'll continue to be represented by counsel, including at trial, if that's what you want. You understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that are summoned for jury duty on your trial date. Once they are selected, the evidence will be presented, and then the jury will be instructed on the law. And then that jury would decide by unanimous verdict, meaning all 12 would have to agree, as to whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means to give up in writing, your right to have a jury trial. And in that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, the judge would be the one who would hear the evidence. The judge would apply the law. And the judge will decide whether or not the state proves your guilt. You understand that?
Yes, Your Honor.
All right, now under the Constitution, you have a right to confront the witnesses against you in open court and cross-examine them through your attorney. That means that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else. How much? 11. Okay, and anyone else is present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
All right, now under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, you request the court will issue court orders called a subpoena, and that would force the people named in that subpoena to come to court to be available to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, Your Honor.
All right, now originally you entered a plea of, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence or to testify against yourself at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can. It's up to you. If you decide not to testify, the fact you did not testify cannot be used against you in any way by any person. No one is even allowed to comment about it except in one situation. If there's a jury trial, you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you're presumed innocent of the charge until proven guilty by the state of Ohio on every essential element of the offense charge. So what that means is the burden of proof is not upon you to try to show you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
Now, originally entered a plea of not guilty. Not guilty plea denied the allegation of the indictment, denied committing any crime, and exercised or revoked all the rights I've just described. Withdraw your not guilty plea, plead guilty to count one. That is the opposite of not guilty plea. Guilty plea will admit the allegation in count one, admit that it's a crime, that you committed that crime. And that plea will waive and give up all the rights I've described for you this afternoon, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty will waive and give up your right to a jury or court trial. It'll waive and give up your right to confront witnesses against you and cross-examine them through your attorney. It'll waive and give up your privilege against self-incrimination, because if you say you're guilty, and that's what's used to find you guilty, it will waive and give up your right to use the power of the court to compel or force witnesses to be in court on your behalf, the same as the state. It'll waive and give up your presumption of innocence, because if you say you're guilty, that's what then the state doesn't have to prove you're guilty. It also waives and gives up any right to file an appeal that you think you may have had up to this point in the case. Now, if I sentence you to the maximum sentence, under other limited circumstances, you can file an appeal, which must be filed in 30 days of your sentencing entry being filed. And finally, it does subject you to being sentenced immediately by the court. Do you understand all that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
And again, you're entering into this plea agreement voluntarily.
Yes.
Now, do you have any questions about the charge or the possible penalty?
No, Your Honor.
You understand it?
Yes, I do.
You have any questions about the plea agreement?
No, I don't.
You understand it?
I do.
And again, you understand the recommendation on sentences and binding on the court?
Yes, I do.
Have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes, I do.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes, I do.
All right. Do you need to speak with your attorney about anything before we go any further?
No, Your Honor.
You have any questions at all about anything I've explained today?
No, Your Honor.
Right, then as the charge of count one, which alleges that on or about, move the file around here, lost the file. On or about February 2023 in Highland County, Ohio, you did operate a motor vehicle as defined in ORC section 450101 as willfully to elude or flee a police officer after receiving a visible audible signal from a police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle by the offender causes substantial risk of serious physical harm to persons or property in violation of section 2921.331B of the Higher Revised Code, 3rd-degree felony of failure to comply with the order signal police officer, carrying a possible prison term between 9 and 36 months in increments provided by law, a fine of $10,000, a mandatory life suspension of 6 months to 5 years. How do you plead?
I plead guilty.
Right to court finds on this day in open court, defendants advise all the constitutional rights made in no intelligent voluntary waiver of the same pursuant to criminal 11. The pleas accepted or filed. Defendants found guilty of the first count as charged therein. Counts 2 and 3 are dismissed. Court will refer this matter for a pre-sentence investigation under the same bond. And it'll include an assessment for substance abuse disorder treatment and mental health treatment. And the sentencing will be on July 20 at 1 p.m. All right, is there anything further from counsel?
No, Your Honor.
All right, thank you. All right, Andrew D. Johnson.
Yes.
Case number 22-CR-249, State of Ohio versus Andrew Dale Johnson. You're Andrew Dale Johnson, appearing there for the probation department?
Yes, sir, Your Honor.
All right, this is a pretrial being conducted by Zoom. Mr. Johnson is charged with aggravated trafficking and aggravated possession of a fentanyl-related compound. This is a final pretrial trial set for July the 10th. Looks like discovery is complete. Is that correct, counsel?
I believe so.
All right.
Yes, Your Honor.
All right, and there's no pretrial motions, correct?
That's correct.
All right, now what's the status of the case?
The state's prepared to go to trial on the 10th.
All right, is this going to proceed to trial then, Ms. Hatner?
Your Honor, I need my client to get in touch with me so we can discuss that.
Okay. Well, Mr. Johnson, you need to get in touch with your attorney. So where are you living?
107, right, 10735 Hiawatha Drive.
All right.
I didn't catch that.
He's down at Hiawatha Drive. What is your phone number?
937-763-1771.
All right. And is that your cell phone or somebody else's?
That's my cell phone.
All right.
I need you to call my office to make an appointment to come in and talk to me so we can go over this stuff.
All right. You want to give him your number?
Yep, it's 937-393-3487. Don't just call and say you called. Schedule. You need to actually schedule an appointment.
All right. So you call her and get an appointment scheduled, Mr. Johnson, because the court has a rule that you cannot plea bargain after 14 days. So this hearing's set for July the 10th, so you're running out of time. That only gives you till a couple more weeks, but don't wait till a couple more weeks and call her. In fact, call her office in the morning to schedule that appointment. And when's the next time he's to report to you, Mr. Arjima?
I don't have one yet, so just knock on my door, we'll schedule it.
All right, see Mr. Arjima before you go out. Mr. Arjima, put it on your notes that when he comes in, ask him if he's got an appointment with his attorney or if he has seen her. We need to be in touch with her.
I could go today, Catherine, if you're not busy.
I am booked up. I book up almost 2 to 3 weeks in advance, which is why it is important that you call and schedule, because I am booked full.
Okay. So get that done as soon as possible. All right. Anything else?
No, Your Honor.
All right. Now, is Joanne Shapely there at the probation department? Where there's a mic and it says unmute. Joanne Shapely, I don't have her file.
I think I might have took it.
All right, can you go get it? All right, are you Joanne Shapely?
Yes.
All right, this is case number 23 CR 60, State of Ohio versus Joanne Sue Shapely. This is being conducted by Zoom, a pretrial. She's appearing from the probation department. Her attorney is Danielle Witt. Appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. And I believe, I don't have the file. Apparently, Mr. Reno picked it up when he grabbed some of the other files. She's just charged with one count of aggravated possession.
It's a felony of the 3rd degree for being in an amount equal to or exceeding bulk, but less than 5 times bulk.
Okay. All right. And I see here we have a plea form. All right.
That's correct.
Now, Ms. Shapely, this is a 3-page agreement, and I'm going to hold up the screen and ask you if you recognize that first page there. It says you're going to plead guilty.
Yes.
All right. And on page 3, there is a sentence about not quite halfway down the page, says I enter this plea voluntarily. Immediately below that is a signature, a neat signature of Joanne Shapely that I can read. Is that your signature?
Yes.
When did you sign this agreement?
Yesterday.
And when you signed it, did you understand it was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes.
And did you go over this with your attorney and have her explain everything to you before you signed it?
Yes.
Do you feel you had enough time to fully consider the matter before making this decision?
Yes.
And did you enter into this agreement to plead guilty voluntarily?
Yes.
And you still want to do that today?
Yes.
Now, the agreement states you're going to plead guilty to the single count in the indictment of aggravated possession of methamphetamine under 2925.11 of the Ohio Revised Code of 3rd degree felony, and that you understand that carries a possible prison term between 9 and 36 months, a fine of $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. There's a presumption that you should be sentenced to prison, but it's not mandatory. Do you understand that?
Yes.
Are you facing any felony charges anywhere else?
No.
Are you on probation, community control, post-release control, or parole for a felony?
Just a pre-sentencing for this case.
All right. Now, under the law, if you are sentenced to prison for this offense after conviction, you could, upon completion of that prison term, be put under post-release control supervision by the Adult Parole Authority for a period of up to 2 years. It's optional, but they'll make the decision. If they do, you'll be supervised on the terms they set by a parole officer. If during that period of time you are found to have violated those conditions, they can return you to prison and make you serve an additional period of up to 9 months for a single violation, up to a maximum of half your prison term for all violations. But if you commit a new felony, in addition, whatever sentence a judge in a new case can impose upon you, a judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively the sentence in the new case. Do you understand that?
Yes.
Now, I'm not required to sentence you to prison for this offense. I can impose community control probation, which means you'd be supervised by a probation officer on the term set by the court for up to 5 years, and if during that period of time they felt you were not compliant, they would have to file an allegation of that with the court in writing, give you a copy. There would be a hearing. You'd be entitled to have an attorney to represent you at that hearing. If the outcome of the hearing was you failed to comply, then at that time the court could revoke your community control and then sentence you to prison for 36 months and fine you $10,000. Between 9 and 36 months and fine you $10,000. Do you understand that?
Yes.
All right, now the charge alleges that on or about December 17, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in an amount equal to or exceeding bulk amount but less than 5 times bulk amount in violation of Section 2925.11 of the Revised Code. So that's the charge of aggravated possession of methamphetamine, the third-degree felony with the penalties I just described. Do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes.
Discuss the charges, the evidence in the case, possible legal issues of the case, possible defense you can try to raise in trial, and possible outcomes of a trial with your attorney.
Yes.
Are you satisfied with her advice and competence in this matter?
Yes.
Are you under the influence of any types of drug or alcohol at this time?
No.
Are you taking any prescription drugs?
I have a steroid that they gave me for strep throat.
Okay, but other than that, nothing else.
No.
Have any threats been made to make you plead guilty?
No.
Now, at the bottom of page 2, there are a couple of lines printed in bold. Part of one of those has been marked out. So what's remaining reads as follows. Defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend committee control and referral to drug court. Is that your understanding of the agreement?
Yes.
Has anything been promised to you other than that to get you to enter into this plea?
No.
Now, the matter of sentence is up to the judge, so even though there's a recommendation that you get probation or community control and be referred to the drug court, that is up to the court. So once I've heard all the information presented, if I find that's not the correct disposition, I could go ahead and sentence you to prison for a term between 9 and 36 months, fine you $10,000, and suspend your license for 6 months to 5 years. You understand that?
Yes.
All right. Now, do you hold any type of professional license or certification from any state governmental agency?
No.
Right now, before I can accept your plea, you have certain constitutional rights you must understand. First, you have a right to have an attorney, and I appointed Ms. Witt to represent you. Now, that appointment wasn't simply to work the case out, but to provide whatever defense might be available to you under the law that you would like her to provide. So if you decide that you do not want to do this, that you would rather defend against the charge, she'll continue to represent you, including trial, if that's what you want. Do you understand that?
I understand.
Right now, under the Constitution, you have a right to have a jury trial in this matter in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They'd be instructed on the law. Then that jury would have to decide by a unanimous verdict, meaning all 12 would have to agree, as to whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial. And in that case, you would have what's called a court or bench trial. And that means that instead of the jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes.
Now, under the law, you have a right to confront the witness against you and to cross-examine through your attorney. What that means is that the witnesses against you have to come into court, testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is to bring out evidence that would help your side of the case. Do you understand that?
Yes.
Now, in the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, you request the court will issue a subpoena, which is a court order that forces those people to come to court to be able to testify, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence or to testify against yourself at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact you did not testify cannot be used against you in any way by any person at any time, and no one can even comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you're not even required to present any defense. You may, but you're not required to. But whether you do or not, the burden will remain upon the state of Ohio to prove your guilt on every essential element of each of the offense, which is by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Originally, you entered a plea of not guilty, which denied the allegation, the indictment denied committing a crime, and exercised or invoked all the rights I've just described. If you change your plea from not guilty to guilty, that's the opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits it as a crime, that you committed that crime, and that plea waives, gives up all the rights that I've just described, except the right to have an attorney, which you always have no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront the witness against you and cross-examine through your attorney, would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, that's what's used to find you guilty, and would waive or give up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It's subjected to being sentenced immediately by the court, And finally, it would waive or give up any right to file an appeal that you feel you may have had up until this point in the case. Now, if I sentence you the maximum sentence, or under other certain circumstances, you could file an appeal that would have to be filed within 30 days of your sentencing enter being filed. Do you understand all that?
Yes.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge, the possible penalty?
No.
You understand it?
Yes.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
Again, you understand the matter of sentences, recommendations not binding on the court.
Yes.
All right. Do you have any questions about the constitutional rights I've explained?
No.
You understand those?
Yes.
Have you any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
No.
You understand?
Yes.
Do you need to speak with your attorney about anything before we go any further?
Not that I know of.
Do you have any questions at all?
No.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of the plea agreement we've just gone over?
Yes.
And as to the charge, which alleges that on or about December 17, 2022 in Huntington County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, an amount equal to or exceeding bulk amount, but less than 5 times bulk amount in violation of Section 2925.11 of the Ohio Revised Code, charge of aggravated possession of methamphetamine, third-degree felony, carrying possible prison term between 9 and 36 months, a fine of $10,000, and a license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. The court finds on this day in open court, defendant was advised of all of her constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted, order filed. Defendant is found guilty of the charge and set forth in count 1. The matter is referred to the probation department for a pre-sentence investigation, including an assessment for mental health and/or substance use disorder. The case is also referred to the drug court for evaluation. The matter of sentencing will be set for July the 20th at 1 p.m. All right, is there anything further in counsel?
No, Your Honor.
All right, thank you. Do you have anyone else there at the probation department, Mr. Arjima? I don't know. That's why I'm asking. Keep it up.
I believe Mr. Pauly is at the probation
Mr.
department, Your
Paula?
Honor.
Okay. CR 56. State versus David Williams, 23 CR 56. Present on behalf of the state's Assistant Prosecuting Attorney King. Present on behalf of the defense attorney Jacob Wagner. And you are David Williams?
Yes, sir.
All right, Mr. Williams is charged with failure to register a change of address as a sex offender. This is the first pretrial, final pretrial set for July 5, trial set for July 24. I see that there's a request for discovery and compliance. All right, so Mr. Wagner, your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
Not at this time, sir.
No.
Has there been a written plea offer provided?
And related.
All right. So is there anything else then that needs to be discussed at this time?
No, Your Honor. Only, if I may, Your Honor, my client did inquire. I told him just run everything by Mr. Irajima as far as his house arrest issues. He said Eric's been very good with him working when he can and cannot leave. I indicated it's typically the courts. As long as Eric says he can do it, that's okay. Is that?
Do what now?
As far as his house arrest, he was asking about if Eric gives him permission to, do certain things. Is he allowed under your court's order?
He can be allowed to do the things that I said in my entry.
That's what I mean. He's not going outside of it. He just didn't know how long. The 4 weeks, report for the first 4 weeks, he's done that.
I'm not sure I understand the question. If Mr. Arjima is letting him do what I said in the entry, then what are you asking?
Well, he was asking, I guess, I know you
Who's asking?
Huh?
Who's asking?
I'm asking. I know.
Okay,
typically,
you said he was asking. All right, yeah, I'm confused.
He asked me for clarification, how you normally say the first 4 weeks you'll report, you're on house arrest and check in. He asked me if the conditions the first 4 weeks are still in place. So my question is...
Well, how long has it been? He reports once a week for 4 weeks. After that, as Mr. Arjima or the probation department tells him.
And that's what I told him.
But all the other conditions apply until the case is complete.
Yes, that's what I just wanted to confirm. He reported the first 4 weeks.
That's in the entry.
I was just confirming that, Your Honor.
Okay. Been easier to read it. All right.
Sorry?
I said it would have been easier to read it. All right. Anything else?
Nope.
All right, thank you. All right, what is your name appearing there from the jail? All right, case number 23 CR 86, State of Ohio versus James Richard Pauley. Mr. Pauley is appearing by Zoom from the probation department. This is a pretrial. His attorney is Sarah Barger, and she is appearing from her office. And appearing from the prosecutor's office is Prosecuting Attorney Collins. The defendant is charged with aggravated possession of methamphetamine, a 5th-degree felony. This is a first pretrial. Final pretrial is set, I believe, July 5th, and the trial date is set for the 27th. I see bill particulars and discovery has been provided. The defense discovery will be due by the final pretrial. Anticipate any pretrial motions, Ms. Barger?
No, not at this time.
Has there been a written plea offer provided?
There has.
Is your client aware of it?
Sorry, Annika.
That's all right.
No, he is not. We've been playing phone tag.
Oh, okay. All right. Well, Mr. Paul, you need to get in touch with Ms. Barger so you can make an appointment.
I've been trying to tell him.
Yeah, well, just continue. Sometimes that happens when people are busy. And we'll get to do that. And you did provide your prescription, it looks like, for what you've had on OxyContin. But I see you did testify positive, or test positive in April for a number of things you don't have a prescription for. So you're supposed to go back tomorrow, or today, you're supposed to go to FRS. Have you been there yet?
Yes.
All right. You're going to go to treatment?
Yes, I'm in treatment now.
All right, good. All right, good deal. All right. Anything else we need to discuss?
No, Your Honor.
All right, then your next pretrial will be July the 5th. Thank you, Mr. Pauley.
All right. Thank you.
All right. Now, is she present there?
No, Your Honor. I haven't seen her since
I
she
see.
came
Okay.
in after her arraignment. That was it.
All right, well, I'll go ahead and call the case. This is case number 23, CR 70, State of Ohio versus Brandi Lee Moore. This was set for a Zoom pretrial. Ms. Witt, Daniel Witt, the attorney for defendant, is present from her office by Zoom, and present for the state from her office is Prosecuting Attorney Collins. Defendant is charged with receiving stolen property, 4th-degree felony. She's not reported to the probation department today for this, and when we sent the assignment notice and gave her assignment notice, it was for in person. She is not present in the courtroom and has not been present since 1 o'clock. The matter was set at 2:15, and it's now 3:07 according to my clock. I do have a report from probation that indicates that she stopped there on May 17 and has not had any contact since then, even though she's supposed to be reporting once a week for 4 weeks. Ms. Witt, have you had any communication from Ms. Moore?
No, I haven't.
And probation department's had no other contact today?
That is correct, Your Honor. We have not.
Well, then the court will order that a capious issue, the matter be put on the inactive docket until she is located, and when she is, we'll bring her back before the court and get the matter rescheduled. All right, I believe that's everybody. All right, you don't have anyone else there? I haven't called Mr. Arjima?
No, Your Honor.
All right. Thanks for all your help in getting all these people in.
No problem.